21. May it please your lordship.
Sure.
My lord, with absolute reluctance, my lord, I beg your lordship's pardon to mention yesterday's item which your lordship has reserved for orders. My lord, your lordship has asked us to pay 50,000 rupees. We are willing. Only on one reservation, it appears that this Shishu Sarathi, that organization, the director is the writ petitioner. So your lordship, you may direct any other authority.
Sorry, sir, we have already signed.
Well, I'll file a application for review.
Whatever option is available to you.
Yes, madam. I'll file an application for review. Only to that extent, because otherwise, madam, it will be, they're saying that he has other 10 cases like that where he has gone to a restaurant, and so we'll file an application for review, madam.
That doesn't mean in every case.
Yes,
It is that the
Madam-
court is going to pass an order. But simply since you said that you know, this reservation in depositing the same, and ultimately it's a organization.
But it is the director is him, and he is the so means the all in all of the
But
organization.
ultimately, it's an organization taking care of or some imparting some social awareness about the disabled person.
His main purpose was to is this one. This is not the first time that has happened in the city.
So we have already.
Madam, we'll file a review. Your lordship may dismiss it, madam.
May please, Your Lordship. My lord, in item 22, I have filed a affidavit in opposition yesterday, which is not on record. Lordship may kindly call for it, madam. Item 22, madam.
Have you informed the other side? Who is for the other side?
My lord, the appellants, my lord. I have served copy to them, my lord.
But have you informed them?
My lord, only am I asking for calling for the
Okay,
affidavit.
today only. na?
Yes, yes.
Okay, call.
Obliged, madam.
Yes.
May I please, Your Lordship? I beg to mention item number 10, Your Lordship. Here, Your Lordship, inadvertently, you will fail to provide a copy of the appeal memo to the respondent, Your Lordship. Right now, I have provided a copy to him, Your Lordship. Let this matter may come up some other day, Your Lordship.
I have
Yes.
received a copy today. I'm appearing from respondent 1 and 2, Your Lord.
Okay, at the request of the concept of the applicant, appellant, is this matter also, and so whatever the convenient date you please.
Lots. Obliged, Your Lordship.
Obliged.
May plead your lordship. With the consent of all the parties, lordship, I beg to mention item number 44 to 49, lordship. Connected matter. Lordship, I pray, lordship, a fixed date, lordship, on, if possible, lordship, on 18 April, lordship, all the parties are there. We are all agreed, lordship, 18 April.
Joint request of the parties, let these matters on 18th of April.
Obliged, lordship.
Also, on that day, hearing should be.
Yes, lordship.
It is listed for hearing.
Hearing.
Maybe it is listed for hearing.
Obliged.
May it please your lordship. With all humility, my lord. Item number 35. May I seek an accommodation, my lord? Would it be after 4th of March? I have the consent. I have
Lordship, I am appearing for the respondents.
after 4th.
Whatever the date you want.
Lordship, obliged lordship, grateful.
This one for.
May I please, Your Lordship.
So item number 41, of today's daily list. I filed adjournment slip yesterday also. The thing is that the new council has been, I think, by the petitioner. Yeah, by the petitioner, a new council has been engaged.
You are the
So we
new one.
accept.
You are
No,
the,
no, my senior as the sir.
the request of the land concept for the petitioner. This one for it.
May it please your lordship, in item
Obliged.
33, we had filed an additional affidavit yesterday, which is not on record. The same may be called for, Lord.
Item number 33,
Yes, Lord.
call for the.
May it please your lordship. I beg to mention, lordship, my lord, this writ appeal was filed yesterday, my lord. I may be allowed to move this writ appeal on Monday, my lord.
You are seeking permission for listing a writ appeal.
Yes, my lord. On Monday, my lord.
Yes.
Obliged.
I plead your lordship. I beg to mention item number 29, your lordship. 29.
Yeah.
Due to personal difficulty of my senior, your lordship, we pray for it to be listed on Monday, your lordship.
Monday,
Monday, lordship.
what's the urgency in that? Okay, Monday.
Obliged.
May it please your lordship, I would like to mention item number 27, lordship.
Yeah.
Lordship, I have received the instruction, lordship. Petitioner is not interested to pursue this case, lordship. I will be permitted to withdraw it. He secured a job in another department.
The petitioner submitted that, submitted on instructions that he, the petitioner does not want to press this writ petition. Appellant does not want to press this writ appeal. In view of the writ appeal is dismissed as not pressed.
Lordship.
May I please, Lordship? Item number 13, may I beg to mention?
Item number
39, Lordship.
39.
My lords, 39 and 40, my lord. In the 40, in item number 40, they were directed to file affidavit, my lord. They have not filed yet, so there's
As
an
in-
appeal by the government, man.
As instructed by my senior Lordship, 2 weeks may be granted.
Yeah, learned counsel appearing for the respondents, placed for and granted 2 weeks time to do the needful. Just after 2 weeks,
My lord, the order is of 11/10/2023 when they were directed.
do the needful as per the order passed by the court on 11/10/2023.
Much obliged, man.
May I please your lordship? Lordship, I beg to mention item number 23, 36 and 37, lordship.
36 and 37.
Yes, lordship. Lordship, CGC, Mr. B Chakravarti is unwell. So lordship may come off after 2 weeks. And lordship, in item number 36, interim order may continue.
You are appealing for the other.
No, no, my lord.
Yes, who you have informed the other side.
No, lordship. Yes, lordship.
No problem, no objection. Okay. At the request of the council for the appellant, this matter after 2 weeks. The interim order WPC 5537/2023 is extended till next date.
Petition, lordship.
Twenty-six is also 26, 36 and 37. 23, I'm sorry. 23, 36 and 37. अलग-अलग करते ना 36 और 37 तीनों में अलग-अलग. Yes,
May I please, your Lordship? Lordship, I beg to mention item number 16 of the daily list, my lord. Here in this matter, I would like to withdraw the IA, my lord. I have made a mention on Tuesday for withdrawal of the same, my lord.
IA, you wants to withdraw.
My lord. I was filed for grant of leave to file lead appeal, my lord, against the order passed by the civil judge.
Then consequently, writ appeal will also go.
My lord, my lord.
Learned counsel for the petitioner has submitted that, submitted on instructions that he wants to withdraw the IA number so and so. In view of the above, permission for withdrawing the IA number so and so is granted. Consequently, the writ appeal 11/7/2024 is also dismissed.
The interim order may be vacated, my lord. There is an interim order of this matter.
Once it is
Well,
dismissed, interim order is automatically.
Obliged, my lord.
Daily list for orders, item 1.
Wait, please, your lordship. Lordship, it's matter for steps, lordship. We are not able to find the present address of the lordship petitioner to respond. So lordship may grant sometime, lordship will,
Need some more time to.
lordship.
As per the office report, service on the sole respondent is not complete, and as the address mentioned, as the address mentioned is not correct address. Learned counsel for the petitioner placed for and granted time to furnish the fresh address. List after 2 weeks. A fresh address of the sole respondent. List after 2 weeks.
Obliged, lordship.
Item 2.
May I please, lordship? Lordship, here we have to file a short reply, lordship, to the rejoinder, lordship. Lordship, 2 weeks time may be given, lordship.
Rejoinder affidavit received.
Lordship,
Think so it is already filed.
Lordship,
Rejoinder affidavit received.
they have filed the rejoinder to the respond number 2, lordship. So we have to file a reply to it, lordship.
You want to file a reply to his rejoinder?
Lordship.
That's not permissible.
How can it be?
Can't go on like
It's
this.
gone like this.
Readings are complete.
Lordship, as
Reading
informed,
has been completed. Reading has completed, Your Lord.
Contempt.
We will not allow this rejoinder and then counter to the rejoinder, then again he'll file something and all.
Lordship, an additional affidavit may be an additional affidavit, Lordship.
What?
There's some new fact is there, Lordship, which has been
Contempt by
informed to
what are
us.
the new facts?
Lordship,
Contempt by what are the new facts?
Lordship,
Plain and simple, whether you have complied with the order or not, it's all. You have to explain whether you have complied with or under what condition you are not going, you have not been able to comply with the order.
Lordship, this matter was relating to a construction of a road, Lordship.
Construction of a
Road, Lordship. And Honorable High Court had directed to complete this road along with the road which in accordance with the specification of central government, Lordship, the 2-lane road, Lordship. But at that point of time, this could not be done. It was done later on, Lordship. And moreover,
So either your case is you have complied with the order of the court.
Lordship, the work is still going on, Lordship.
Madam, may I just please, madam? Madam, the road that the petitioners had espoused, madam, at the time of the petition, when the PIL was filed, madam. That pursuant to direction of this court, madam, to complete it within 2 years. That couldn't be done, madam. Your lordship will kindly realize, madam, the Arunachal, madam, mountainous terrains and so many projects are dependent on the, madam, the weather, madam. But anyway, all these projects were being followed in pursuant to the, my lord, the direction. And my lord, what has happened, my lord, that particular stretch was divided into three stretches later on. One became a highway, so there is no issue, my lord. And another also became a road, my lord. Now the issue that is being possibly, if I understood, my lord, in his affidavits correctly, my lord, a stretch of 6.25 kilometers. Which they see that it should be two lane as directed by the division bench earlier, my lord. Now we say in our affidavit that we have filed, my lord, that it is not possible because of the, my lord, technical geomatics, their hairpin bends and grades. But this is not done by us as per our own wish, my lord. We have done it as per the guidelines of the MOT, my lord, Ministry of Road Transport and Highways, my lord. So therefore, my lord, and the requirement of the public has also changed in the meantime, my lord. One point has been, well, because of the construction of the highway, somehow that Basti has come down. And there they have filed a rejoinder affidavit, my lord, bringing up against press allegation, my lord. Even if it is rejoinder, my lord, we may be permitted to file a short, my lord, we will file not as a reply to it, but as an additional affidavit. But the purpose is already served. Why it is being continued, we do not know. And we have been 60% of that 6.25 kilometers.
Mr. Goswami,
Yes.
then was it not necessary for you to file an application for modification of the division bench?
At that level, madam, I agree, madam. I understand, madam. I with
Because you
utmost
were
humility,
sitting
my
in
lord,
the
I
court
agree,
of the
madam.
Court's order.
I agree, madam. But what was sought, madam, in the judgment also, my lord, our stand was contained, madam, just.
The order is of 2014.
Yeah, 2014.
You are required to.
And what started in
instruct the court
2022,
as per
madam?
its
Let me also
proposal
make,
sent to the MOT within a period of 2 years.
my lord, and what started, madam, let me make myself clear, in the year 22. So far as the 6.25 kilometer is concerned, rest is no issue. madam.
This 6.25 kilometer is to be constructed by which authority?
By the PWD, madam.
PWD Arunachal Pradesh.
With central fund. Yes, ma'am. With central fund, ma'am, from what? Ministry of Road Transport and Highway.
What is
And the work is going on, my lord. 60% is done, my lord. On the next
Instead
day,
of-
my lord,
Instead of laying down 2-lane roads, you are laying down one lane road.
one lane road, my lord. According to my lord, the technical, this thing, man. We have stated in our in para 3.
Now, what it means then,
My lord.
already explained the situation under which you can construct the two-lane road. Then
Well,
what
two-lane
remains-
is-
What do you have to file there?
My lord, two lane is not advised there, my lord. So therefore, and the traffic is less, and then there are a lot of hairpin bends and grades, my lord, lot of gradients. And this has been approved by the central government, my lord.
So you have sent a proposal to the MOD for construction of two-lane.
My lord, my lord.
So is there any
They declined with it, my lord. In para 3 of the para, they said,
the MOD,
yes, sir.
where is that order?
My
for
lord,
the
my
MOD?
para in affidavit by the PWD at para, is para 3, my lord. May kindly be said.
Page,
But by affidavit in opposition by respond number 2, PWD. May I just read out, my lord, paragraph 3, my lord.
you please
Page number 1.
indicate this
Paragraph 3, my lord.
paragraph P at page
Page 150, my lord, it will be 150.
150. You have the respondent number 1.
My lord, we are for 2 and 4, but 2 is the PWD, my lord, respond number 2.
You read out.
So far as that ongoing work is concerned, my lord, this 6 point, which has been done with the width of 3.75, this is about 12 feet, existing road that was being made. May I read out, my lord?
Yes,
That the deponent would like to apprise this honorable court about the matter and before adverting to the parawise comments of the contempt petition. The deponent joined as Commissioner PWD on 14/2/2020. The matter relates to construction of road from Nechipu to Hodge, length 252.21 kilometers under Ministry of Road Transport and Highway. This is the GBFOT, that is my lord explained, design, build, operate and transfer project started in the year 2013 and completed in 21. Prior to the implementation of the DBFOT project by MOT from Nechipu to Hodge, the existing single lane road was constructed and maintained by BRO, that is Border Road Organization. During the DPR and construction stage, the double lane DBFOT road constructed by MOT bypassed the existing BRO road at 4 locations in various chainages, namely Kupi segment, Nepua Cheda. That is, my lord, this road crisscross, the same road, my lord, in separate thing. Nepua Cheda segment, Sedi Pakro segment, Kodaso to D Dolo segment. Now, out of these 4 segments, must see that Sedi Pokro is the relevant segment. Sedi Pokro. Sedi Pakro, that is being constructed, and I'll come to the next time. The proposal for the double lane could not be implemented as per Honorable High Court order, as the said locations were already bypassed due to difficult geometric involving numerous curves and hairpin bends, which were not conforming to develop construction of a 2-lane highway, as per specification and standard prescribed by the Indian Road Congresses and Ministry's extended guideline. The said reasons were already appraised and submitted by the MOT in paragraph 8 of affidavit by this deponent during PIL. In that PIL itself, we had submitted one. Thus, the state PWD Highway Department had submitted an estimate for maintenance and upgradation of existing road, which is 3.75 meters width to intermediate lane, that is 5.50 meters width, to the ministry through regional officer, MOT Itanagar, by letter dated 26/7/2017 for an amount of rupees 235.77 crore for one-time improvement of the above bypass, bypass existing road segments in accordance with ministry's circular dated 23/4/2003. So ministry had a circular for, they give funding for one-time development, my lord. The same was turned down by the RO office by letter number so and so dated 4/9/2017 on the pretext that development and maintenance of these missing links are state PWD's responsibility. And there is no provision in the contract agreement of DBFOT. Again, in reference to letter dated 4/9/2017, it was directly submitted to the ministry by the then Commissioner PWD Government of Arunachal Pradesh, Itanagar, by letter dated so and so. Meantime, some of the segments like Kodaso to D Dolo, 21 kilometer, and Sedi to Prizirang CO headquarter length 15.60 kilometer were taken up for construction under PMGSY 2 by Rural Works Department. This is another department, Rural Works Department. Pursuant to this, a letter dated 24/11/21 was issued by the MOT Regional Office, Itanagar, to the Chief Engineer Highway Zone PW to re-examine the estimate. On the basis of the ministry circular dated 23/4/2015, again an estimate for rupees 51.98 crore was submitted for improvement of balance work of the bypass stretch of 34.72 kilometer to Aro. MOT Itanagar by letter dated 29/10/21. After various observations and subsequent clarification by the state PWD, finally an amount of rupees 19.115 crore was sanctioned for existing single lane. That is 3.75 meter based on traffic volume. Your Lordship will kindly note this, based on traffic volume for 3 segments, namely Kupi segment 9.20 kilometer, Nepua Cheda segment 9.10 kilometer, Veo to Pizirang care of 6.25 kilometer. Work is going on in this stretch, man. Veo to Pizirang CO 6.25 kilometer. The total of so and so, and the same was sanctioned by the Ministry of Road Transport and Highways by approval dated 33/2022. Under the sanction amount, the work has been taken up by call of NIT and work is 27% in progress as on 36/23. This was filed earlier, man. Now it is more about 60%, man. It is to be mentioned here that Daula village falls between Sedi to Pizarang TO, that is Circle Office Headquarter Road, which has been taken up under PMGSY 2, and Patua village falls between Sedi to Vio NH 13. The existing BRO road between Pizirang CO headquarter to Pakro has been abandoned and not taken up for one-time improvement on public request and also on the basis of unofficial note issued by the MLA 12 Pake Kasang STSC on 22/11/2021, as all the inhabitants have shifted to the VO village. They have come down, my lord. So therefore, one stretch was left out. That with regard to the statement made, my lord, this is essentially what we are stating, and this stretch, my lord, VO to PZR, my lord, there is a map annexed. This is the map one. My lord, it is at page 196 annex RL, that will clear. Last page will. Your lordship will find one green line in between, my lord. About the middle of the map. From PZR Circle Office headquarter to VO. This has remained single lane. And is under construction, my lord. And this is being objected to, my lord, by the petition.
No.
But this is done, my lord, as per the. Single lane
PRT road.
Etu road to hoy gol. Etu road hoy gol. This road is etu area ko RW.
PMGY road.
Oh, PMGY RW.
Yes.
Well, physically, no road was constructed till now. They said 23% has been constructed.
27% and now he's claiming 60%.
Yes, my lord. What is the physical progress of this work, my lord? There is nothing.
No, what he is saying that it's
27
6.25 kilometers. So it's not due to technical specification, it is not possible to construct.
Already there is a existing, and there is a direction to widen that earlier BRO roads, my lord. That has not been done.
So far as regarding the other part of the order is concerned, whether you are agreeing that that has been complied with.
No, one PMJ road was constructed. There is a direction to construct two-lane highway, but
But
what they have done.
If they are saying that it is not possible on account of due to some technical specifications, then whether we
My lord, that existing, only there is a existing route is there, my lord. There is a direction to widen that road. That has not been.
If they are showing this, that we will not be able to construct the two-lane highway on account of this, whatever the technical specifications. So despite that, we'll ask them, you know, we construct this. What they're saying in their reply appears to be this.
And also, my lord, we are not sleeping, my lord.
Ultimately, if you want to wriggle out of this order,
My lord.
then you have to apply for modification. Otherwise, this order is very clear and after hearing you, despite the strength of the more,
My lord.
that they can't construct the two-lane, the court has issued directions to construct the same. Whether you file the modification application or whatever, advice to you.
You would also kindly grant us sometime, I'll take up the matter with them, my lord. Yeah, but that is there, I also understand. But it is not a fact that we were sitting silent, my lord, because the letters which show 26/7 within that two periods of time.
It's an order of 2000.
14, my
10
lord.
years, almost about 10 years have passed and you are saying we are not sitting silent.
My lord,
What else?
efforts were being made
Still
from
we
within
are-
the 2 years.
Still we are in the process of construction of the roads where the court has given a direction to construct within 2 years.
My lord, we started within 2 years, my lord.
Started to complete, when you will complete.
Sanction came later, sanction.
You started and then you will go on, the 20 years, we will take 20 years to construct the road. That's
My lord, sanction came in 21 and 22, we started the work, my lord.
can be.
And my lord, working time is only 5 months, my lord, in Arunachal.
Right, but 9 months, in 30 months, they have constructed a parliament building.
My lord.
So it's not a matter of nowadays.
Well, I'll take up this matter about the
technology is
modification,
so-
my lord, that problem is there.
Complete your instructions by this or whatever you want, otherwise we'll pass some order on.
Now,
Okay. And concept appearing for
yeah.
respondent, you are appearing for respondent,
I am appearing for Esplanade 2, my lord, and 4.
respondent number 2 and 4. Pays for and granted
One.
to complete his instruction.
1, 2, and 4, my lord, I'm sorry, 1, 2, and 4.
1, 2 and 4 to complete his instructions. This on which date?
3 weeks, my lord, any date.
After 3 weeks. This one so and so.
Much obliged.
Item number 3.
Me, please, Your Lordship. As per the last order, the one-man inquiry committee submitted its report and government is to take a call on the one-man inquiry committee report.
Status report you were.
Yes,
supposed to
I have received an instruction today, Lord. Well,
the report is under active consideration, my lord. Now the authorities, they have sought for some information from the district commissioner for assessment of the compensation, my lord.
Custodial debt and demolition of bulldozer.
The house of the same person was demolished
No, my lord,
Yes,
by bulldozer.
by bulldozer, by the police authorities, without any my lord, written instruction from the higher authority.
That-
That transpired in the affidavit filed in the PIL before your lordship.
Accident took place in 2021.
Yes, my lord, that
It was there.
ablazing of the police stations, the persons whose houses were demolished were the persons accused in that case. And their houses were demolished by using bulldozer and by police personnel without any order. And they are
Now,
saying,
my lord, after the report, my lord, the government has taken, they have asked for some instruction as regard the houses, my lord, Pakka and Kacha houses which were demolished for assessment of the compensation amount. They are in the active, the report is under active consideration, my lord. Lordship may give us 2 weeks time, my lord, so then the,
What about the cognizable offense? What about the death? What about the,
my lord, death of Safiqul Islam is another case, my lord. It was not in connection with this. Demolition is different, my lord. But the report is under active consideration. The report, let the information come, my lord. The consideration will be placed before your lordship.
where is the report of one-man committee?
The report has been placed before the government. Government has considered it, my lord. Copy is not with us, my lord. It is under consideration.
What is ultimately the result of the inquiry? What they have,
Well, As such, the report is not with us, my lord. It is placed before the government. Government has considered as it appears from the communication, my lord. Lordship may give us 2 weeks time, my lord. Let us, along with the information, my lord, the final consideration.
look,
will-
this
will
is
come.
precisely, my lord, this is precisely the submission from the government on last 2 days, that the report is before the government and government is taking a call into the matter.
Let's record before.
Lordship. The
One-man
report-
inquiry
because-
commission report, you place it.
In a seal cover, I will place it.
Maybe see.
Lordship.
Okay.
Lordship.
Learned council appearing, Deenath. Learned Singh,
Senior government.
Mr. Deenath, learned senior government advocate. Placed for and granted a week's time to submit the one-man inquiry committee report before this court. List on so and so.
Lordship may kindly indicate, my lord, I'll place the report in a seal cover. If I, at this stage, at this stage.
Ultimately, it's for our perusal. We are not going to. If required so. We may also inform the court about the measures taken by the state government pursuant, in response to the one-man inquiry report.
Lordship. All right. Deeply obliged.
Item number 4.
Mr. Nath, would you require a copy of this order?
I need it.
Copy of this order be supplied to Mr. Nath
Lordship.
during the course of the, Nath by the registry.
Lordship. All right.
May it please your lordship. My lord, notice upon the respondent number 7 lordship was already served lordship prior to admission lordship, and after admission lordship, again, I have taken steps lordship upon the respondent number 7 lordship.
The service is not complete.
Lordship already complete in this case lordship, because your lordship may kind of office note dated 12/4/2023 lordship, wherein it is clearly stated that notice already served lordship upon the respondent number 7.
Who is appearing?
No one appearing, Lordship. Although she received the notice, Lordship.
What you, he was the respondent before the land single judge also. But on the last few order sheets, the court has specifically passed order that get the notices served upon the respondent number 7.
Your Lordship may kindly see office note dated 12/4/2023, Lordship.
12/4.
12/4/2023, Lordship.
12/4. He's taken over, none of this for the. Need to order the. Yeah, 28 order. You order. Earlier notice, but for sure. Instead of taking note of this, the court has observed that service on the respondent number 7 is effected on 21st of April 2023. Thereafter, the matter was admitted on 8/5/2023, and again the court has issued notices
Yes, Lordship.
to the respondent number 7
Then,
of.
then again, I have taken step on 31/7, Lordship. On 31/7, I have an acknowledgement, Lordship. Again, I have taken the steps, Lordship, upon the respondent number 7.
31/7.
Lordship, regarding that service, Lordship, perhaps there are no occasions. So let the matter may be placed before the Lazima court, Lordship. Or
The court has already you fresh steps, you take the fresh step
oh, okay, Lordship, I will take the question.
pursuant to the order passed by this court on 16/10/2023. No steps have been taken for service upon the respondent number 7. Would stop the net counsel appearing for the appellant undertakes to take steps for service notice upon the respondent number 7 within a period of 1 week. Would stop. On doing the same, let notice be issued to the respondent number 7 returnable. After 8 weeks, returnable after 8 weeks.
Obliged.
Item number 5.
May it please allow. My lord, the matter relates to a contract. What had happened, the respondent number 6. In the initial technical evaluation, my lord, the bid of respondent number 6 was found to be non-responsive. Now, taking note of documents which were admittedly submitted post last date of submission, he was made responsive. That is the case. And learned single judge, my lord, did not find any fault in the process. Then why we have tender system, my lord? Why do you give last date of submission of bid? That's the case. If your lordship would kindly come to Page number 283, my lord. It will go the same. First page. Sorry, no, 283, yes.
Service is complete.
Yes, yes,
Service complete.
yes. Only thing is, my lord, since there is no stay order, the other side is going ahead with the work.
The interim order is dated.
My lord, actually what had happened, the judgment of the land.
7th of September, my lord. The, what was the work? What is the work?
Construction work, my lord.
My lord, it's not ordinary construction, it's a mega project. Let me explain, my lord. It is Lower Subansiri Hydel project, which if completed, my lord, will be the second largest project in the country after the Teri Dam. It is around 2000 megawatt. Now, my lord, this work pertains to downstream of River Subansiri, construction of embankment. Over here, my lord, flood is a very big issue. So, my lord, it is the construction of embankment in the downstream of River Subansiri. So, after the judgment of London single judge on dated 7th of September, my lord, on 13th of September, we issued letter of acceptance, and thereafter the work on the embankment started. It is at the verge of completion. This is my latest information. Verge of completion. Verge of completion. Within, you're saying it's a mega project and verge of completion.
See,
My lord,
I was also wondering.
one need not wonder, my lord. Let me explain. It is the particular work because it is connected with the mega project. This work is the construction of embankment in the river, in the downstream of River Subansiri, embankment. Lordship, the bank of the river. So it is the embankment. Embankment, my lord, stretches 1 kilometer. So this 1 kilometer construction of embankment in the River Subansiri. Because, my lord, because of the project.
The only work interested to you.
My lord, not to me, my lord, I am NHPC. It is my decision which is under challenge.
Answer to the contractor that.
My lord, it is respondent 6 who is the contractor. My concern is the work because there is public pressure also. Monsoon season will start. There will be flood in the river. Embankment is very, very important. And my lord, this 1 kilometer stretch, it is at the verge of completion after the issuance of letter of acceptance.
The contract was awarded only for the construction of 1 kilometer.
1 kilometer to respondent 6. My lord, this work is divided in various parts. The particular part is 1 kilometer stretch in River Subansiri, which is awarded to respondent 6.
Question in this.
Yes, my lord, yes. And my lord, I can satisfy your lordship so far as the merit of the case is concerned.
Then let my lord, he should argue my appeal also. Let him argue my appeal also.
One need not be sarcastic. There is no
I'm
question
not
of
being
arguing the appeal.
sarcastic. I was standing, he stood up. So that's why I've requested him to present my case also.
But I can very well do that. There is no difficulty. Please, don't get personal. Don't get personal. Nobody expects a better words from you.
Can I define the rest of this? Is protection.
Who is appearing for respondent number 6? You're up. We'll do one thing. We'll list it for admission and we'll hear it at the admission stage only. Yes.
Only thing is, my lord, as the SPC, sorry, NSPC council has said, they're progressing. So there's urgency in the matter, my lord.
Yeah, but the one thing is that if they are progressing and almost the work is at verge of.
No, my lord, that may not be correct. What we understand is he has started the work. The statement that my lord is almost on the verge of completion, that may not be correct. My lord, it's a blatant violation of the provisions, my lord.
Do one thing. We'll fix it for admission. In the next week or another next week. And you may argue on finally at the admission stage.
My lord, in fact,
Till then, you may file your status report. What about the progress of the work and supply the copy to the.
Very well, my lord. In fact, I made a phone call. I have received the message or through WhatsApp. 90%, more than 90% work is over.
File an affidavit.
But I'll file an
whatever-
affidavit. I'll file an affidavit.
And you may.
and my lord, since the appeal is pending, they ought to take note of that fact also.
Yeah, sure.
Yes.
Then you may consider.
And my lord, 2-3 important facts, my lord. When the agreement was signed, all right, LOAs was issued on 39 as submitted by my learned friend. Then when was the agreement executed? What is the working period that they have
I
to
think so they have
indicate?
disclosed all this in this.
No, my lord, because that is subsequent to the learned single judge's order. So those facts were not before the learned single judge.
When the agreement was
Yes.
executed and the status of the work.
Yes.
represent-
No, my humble submission would be, my lord, if there is an illegality in the allotment of the work,
That's
lordship will
right.
interfere, despite the fact, my lord, they may have proceeded with at the risk they are doing all these things, my lord.
No doubt.
And my lord, in this very case, by suppressing the material fact, the interim order was obtained from the London single judge. I can, on the very face of it, I will show.
Now
They lied.
that matter ends.
Very well.
That matter
Yes,
ends.
that's true.
The pleadings are complete. This matter for admission.
Service is complete.
Service as well as the pleadings are complete. Pleadings are complete. This matter for admission on 5th of March.
Will it be 2 months if I ask for next week, my lord?
Next week, I think we have already fixed some of the many of the matters. That's why only it may be difficult for us. So 5th of March.
Or my lord, if it is not otherwise inconvenient, could be a 27th or 28th or 29, my lord.
27th.
27th?
27th, I think. we have 6, only 6. Hearing matters.
All right, 5th of March.
Mr. Chaudhary,
Hello.
Mr. Tiwari, as I was just consulting with his lordship, you see, the law has progressed in these matters. We don't know what will be the outcome of the proceeding. But even if Mr. Chaudhary's client succeeds, the end result may not be that cancel the work order and give the balance part. That relief may or may not be possible, regardless of. So in these cases, the contractors are basically interested in two things. Number one, the credit for the work, and number two, the profit component. These are matters which can be considered at any stage. So viewed from that angle, it is doubtful whether there is such urgency in this matter. But that doesn't mean if the work is completed, the appellant is left without a remedy.
Certainly, that's true.
And it also doesn't mean that if he succeeds, the court will order cancel the work,
Yes.
give the remaining. That also,
No, I follow.
keeping the ground realities in mind,
Yes,
may not work
that's-
out. So there are some judgments, few of them have been authored by me also, where disgorgement of contract has been contemplated. So kindly look at those
No,
judgments.
my lord, my humble submission is the Article 14 violation aspects, if it is not gone into by a constitutional court, the remedy of damage is not always efficacious.
That's fine.
Ultimately, what my lord is saying.
No, I'm not disputing that. In fact, my lord, the purpose of inserting that amendment by of amendment that section 41H in this specific relief act, the idea was that. Because at times it was seen that when there is a stay order in case of an infrastructure contract, then eventually it is the public interest which suffers because there will be escalation, etc., etc. But my lord, are we not sending a very,
Despite
sort of
that,
a signal to the, my lord, executive
despite
that because of this constraint, courts will not interfere, so let us indulge in whatever we want.
Despite that, the state authorities can't be set it free to do at their whims. That's right. That's right, and we'll take the remedial measures if the petition, this appeal is going to be decided in your favor, then certainly some certain remedial measures we can adopt for that.
Yes, sir, that can be molded, very correct. my lord.
Relief can be molded.
No, we are fully appreciate what has fallen, my lord. That's the actually the only thing is, my lord, at times here is a case where lordship will find the technical bid was rejected. After the last date, some applications are filed, then they review their decision.
That's not in respect of only one, in respect of the lot 6 bidders, including the appellant. Even the appellant was provided with an opportunity. My lord, even the bid of appellant was defective. Appellant was also provided with an opportunity on the same day.
The pleadings are complete. This will matter for admission on 5th of March 2024. In the meantime, when we consider for the NPCL, what is the
NHPC, National Hydroelectric Power Project.
NSPC may file status report regarding the work, regarding the construction work for which the contract was awarded to the respondent number 6.
And also the payment.
And the details of release of payment. Will stop.
Deep level.
Item number 6. But on last occasion, lordship has issued notice in the matter. The respondents accept respondent number 14.
14. All
They have-
of it, sir.
Accept
please,
respondent number 14, others have appeared.
Yeah, you are appearing?
Yes, Lordship, I'm appearing for respondent number 1, 3 to 5, 3 to 6, 8 to 11, 13 to 15, and 17. My lord, before going into the merit of the case, we have some preliminary objection relating to the maintainability of the writ appeal. That's why we want to file an objection, Lordship.
All the respondents have,
Except
are having the
14.
same,
14.
all the respondents
Lordship.
are having the same grievance or what?
14.
Yes, they filed one writ petition.
One writ petition.
Yes.
14.
14 of them.
Astray.
So if in the office note 14 is not there, if my learned friend appears for the 14, then service is completed. In the office note, service as regard respondent number 14 is not reflected. If my learned friend appears for 14 also, then service is complete.
It's okay.
Yes, sir.
You are appearing for respondent number
Yes.
14 also?
Yes, Lordship.
Lordship. Then kindly post the matter with us next week for admission.
Lordship, 2 weeks time may be granted. We need to file an affidavit and my senior is also out of station due to a medical condition.
Lordship.
As per the office report, notice of the appeal have been served upon the respondent number 1 to 17 except respondent number 14. However, Ms. so and so is appearing on behalf of the respondent number. You give the details, you are appearing on behalf
Yes.
of respondent number so and so. Hence, service of notice upon all the respondents is complete. The so and so place some time to file counter to the submissions. Place for the time to come file the counter. Time paid for is granted list on
March. Another day. March.
for admission.
Okay.
Item 7.
May I pre-
Admission picture again. Admission picture. Service is complete.
Yes,
may I praise your lordship.
the service complete on.
Service
respondent number
complete, my lord.
21.
Service complete.
So services upon all the respondents is
Yes,
complete. Who is appearing for respondent 21?
Lordship, I am for respondent number 21.
21. And all other respondents are also represented?
I represent my restaurant number 530.
All the other respondents are being represented, state and everything. Look here, as per the office report notice upon the, a notice of writ appeal is served upon the respondent number 21 as such. Service of notice upon all the respondents is complete. List this matter for admission. Which date?
My lord, lordship, preferably, my lord, if otherwise convenient, 26th of February.
26th of February.
Item 8.
May I please your lordships? I think both the service lordship, I have filed affidavit also lordship as per direction of the honorable board. Lordship.
15A and 15B.
Yes, lordship.
I am appearing for restaurant number 1 to 14, and so far the legal letters of restaurant number 15 is concerned. They have made contact with us. That
So you are going to,
my lord.
click here. As per the office report. As per the office report, thus the affidavit reveals service of notice upon the respondent 15 capital A and 15B is complete. Mr. So-and-so put an appearance on behalf of all the respondents. Hence, service is complete. List for admission. March की कोई date दे देना.
16 is official respondent lordship.
Which one?
16 is official respondent. he is appearing for 1 to 15 A and B.
So the official respondent is the
No, need not, appear,
performer.
perform.
Okay. This one so and so. May, March की good date.
Deep level.
All right.
Item 9.
Wait, please, your lordship. This is a content matter, your lordship. Basically, your lordship, we have the order of this honorable court, the division bench as well as the honorable single bench. Single bench was upheld by the division bench, wherein direction was given to appoint the petitioner to consider the case of the petitioner for appointment as principal within a period of 1 month. So that was in September, your lordship, and they have not taken any steps to do that, your lordship.
Lordship, today we have entered appearance, Lordship. My brother is for 1, I am for 2 and 3, Lordship. If Lordship permit, I can point out one thing, Lordship, a lot with apology, Lordship. Yeah, here, Lordship, against the single bench judgment, Lordship. We have state has preferred a appeal, Lordship. That appeal was dismissed, Lordship. So, Lordship, as per the rule, High Court rule 1977, Lordship, it should go to the Lordship single bench, Lordship, as per rule 6. Otherwise, Lordship, we have no objection. Just we have pointed out that what the High Court rule says, Lordship.
Go into all these technicalities, comply with the order.
Lordship, we'll do. Otherwise, Lordship, just I have pointed out, Lordship.
Next date come
I just want.
with the compliance. File this compliance report, that's all.
Lordship, will
Is
file.
there any way to wriggle out?
No,
of this order?
I'm not saying that, just I have pointed out, Lordship, just I have
Whatever
pointed
the
out.
maintainability and go.
I'm not saying maintenance part, Lordship.
The technical things,
Just
comply
I'm
with the
pointing out,
order.
Lordship.
Show us the reason that you are not complying with.
Lordship,
for
Lordship.
this reason, that's all.
Lordship, we'll do, Lordship.
Okay. Mr. So-and-so put in appearance on behalf of the respondent number 2 and 3, and Mr. Dinath is appearing on behalf of the respondent number 1. Service is therefore complete. Counter to the contempt petition be filed on behalf of the respondent by the next date of hearing. Put upon, yes. Comply with the order or show us that can't be complied.
Lordship, my lord, after 4 weeks, Lordship, we'll do.
4 weeks?
In a second.
4 weeks में तो consider करने का ही दिया था time. Again, you'll see 4 weeks. Based on 6th of March.
Lordship.
Much.
Item 11.
My lord, in the connected writ appeal, my lord, there are 2 IAs, my lord. My lord, in IA 3402, my lord, we have filed the IA praying for, taking steps on the respondents since they are large in number to paper publication, my lord, which was allowed. And my lord, we have published also. And, my lord, the Leonard Fan, he is appearing for the private respondents.
My lord, I'll be appearing for the respondent number 1 to 53. This is the first time. And my lord, I'll be, if I will be given a chance to file my objection in IA 3109. And since I'm coming out of station, your lordship, from Isle bench, if the matter may be fixed on 22nd March.
Why is it? This is the Isle bench matter.
Yes, my lord.
Why is it here?
No, initially at that point of time, my lord, the order which we have challenged, my lord, we have taken special permission and it got it listed because the order, my lord, by Leonard Single Judge, my lord, was of Honorable Justice N. Salem, my lord. He was presiding there. So there was.
My lord, in fact, I would like
No
to
bench.
ask for transferring the matter to Isle bench because the issue is there in Isle only. The single bench is, orders from passing Isle only. And my lord, there's a DB sitting regularly there. There's a central government council station there, visiting councils there. My lord.
वहां से आना पड़ेगा.
Very difficult for us to come every time, your lordship, so. And your lordship, there are less DB cases than Izol, so here is full packed.
This, what do you suggest? Do you have any objection?
My lord.
I will send to the usual bench.
Lord, I will have no objection, my lord, according to convenience, my lord.
You are also from the usual.
No, I am from Guwahati only.
Go and visit the IUL. The next.
Oblige you, Lord.
Okay. Now the division bench at Aizawl is available, hence the matter is transferred to Aizawl bench. Raised it to do the needful. This, the presence, the so and so for respondent number one.
Jonathan L. silent.
I am for respondent number 54 to 57.
54 to the, जो भी आप लिख के देते हैं सब.
Item 12 and 13.
Yes.
Yes, your lordship, the PIL stands for constituting the Transgender Welfare Board and Transgender State Level Transgender Protection Cell as per the Rule 10 and 11 of the TG Act 2019. After that, what happened is the government reconstituted the board as because the tenure of the previous member came to an end. But here what we saw is where the executives has not applied their mind in a proper manner. Simultaneously, they have picked up some of the community members and they have formulated the board. However, the previous member which was there, it was based on the recommendation by the advisory committee and the core committee, which was constituted by the government. And that advisory and core committee was formulated after the direction of PIL 17, PIL 15 oblique 2017, where the bench was headed by Honorable CJ Ajit Singh and his lordship was there.
Now they this appointed the or nominated the members.
They nominated the members. What?
They bring it recommendation from the advisory board.
No. The present members have, there is no any recommendation for the present members.
Yes.
That is why we are asking is that this process is very arbitrary, where there is no any transparency. There should this has to be stopped. There the government should come up with a new process where the transparency should be there, where each and every community members shall have the right. So generally we want an election process that is required to be done for and fair selection of the candidates to the board. Your lordship, when this PIL was being filed, simultaneously, many of the grievances which are actually required to be adjudicated by the welfare board, that was not done because the committee was there, no doubt, but there was no any office for executing the duties of the welfare board. So pursuant to that, what happened, your lordship will see in one of my affidavit in reply. If your lordship has found.
Yes.
My affidavit in reply, your lordship may just see page 81 annexure 1, which is very disturbing.
Yes.
Here, your lordship, what's happened is some of the trans persons who generally doesn't have any other work or employment. Generally, what they do is they do beg in the train. They were being caught by the police. No doubt, even if they are being termed as criminal, even if they are involved in any criminal activities, we have nothing to say on that part. But arresting the trans person and striping off inside the police station is something very questionable in nature that is required to be dealt with. Now, if your lordship may also see the police report which they have filed.
That is at page.
It is at page 100, starting from 109. Filed by Sanjeev Sekhar Roy, APS, Assistant Inspector General of Police Law.
It is 9.
Starting from page 109. It's an affidavit. If your lordship has found. Affidavit, affidavit, your lord.
Yes.
109.
Shekhar Roy.
Yes. Here your lordship may just see page 114, starting from 114. I will not take much more time. Your lordship may come to 116 page. The second last para I will read.
Yes.
Here it says, the report says, during the course of investigation, above alleged accused person of 4 cases were sent to hospital to identify their genders, and subsequently their medical reports were collected from concerned doctors. After collecting sufficient evidence against the above alleged accused person, they were arrested and forwarded to the Honorable Court of Bongaigaon for allegedly extorting money from innocent railway passengers by masquerading as eunuchs. Charge sheet of the above noted case have already been submitted before the Honorable Court. Now here, your lordship, many questions comes. Regarding the act is very clear. A person who self-identify themselves as a trans, they shall be treated as a trans. The NALSA is also very clear on that part. So how did the arresting authority got the power to striping off this transgender inside the police station and forward it for medical to check their genders? That is something very disturbing. Your lordship, in the concurrent part of Puthuswamy's judgment, what Honorable Justice Chandrachud has stated is, I will just read the para and I will end, your lordship. Here in para 323 of Puthuswamy's judgment, he said, privacy includes at its core the preservation of personal intimacies, the sanctity of family, life, marriage, procreation, home, and sexual orientation. Privacy also connotes a right to be left alone. Privacy safeguards individual autonomy and recognizes the ability of the individual to control vital aspects of his or her life. Personal choices governing a way of life are intrinsic to privacy. Privacy protects heterogeneity and recognizes the plurality and diversity of our culture. While the legitimate expectations of privacy may vary from the intimate zone to the private zone, and from the private to the public arenas, it is important to underscore that privacy is not lost or surrendered merely because the individual is in a public place. Privacy attached to the person, since it is an essential facet of the dignity of a human being. So in that, if that observation is taken into account,
So here, this, PIL.
Yes,
the
your
main prayer is to, this, constitute a transgender welfare board within a period of 2 months, what you have prayed
Yes,
for.
yes, your lordship.
And immediate step for setting up state level transgender cell and to monitor the progress, etc. of the welfare board and so on. Yes, the issue which you have raised is also important. But ultimately, what about these, the prayers which you have prayed essentially in this PIL petition? What happened to those prayers?
Your lordship, that is what I'm saying. The
They have not
first,
constituted the transfer welfare board as per the advice of the advisory board.
no, there is no any setup. Only just committee has been formed and that is on our papers only. Because the previous committee, which was also on papers,
But earlier, as per the order passed by this court, some money was sanctioned by the state government.
money was sanctioned, but we have not seen where that money has gone. Why, how
Not
this
any
money?
office for that.
Nothing till date. No any transparent. We cannot see anything.
What do you want to say, Mr. Consul? What about the setup of this formation of translators welfare board and the office?
Lordship,
The infrastructure.
transgender welfare board has already been constituted.
Yes.
The only point of difference is that in earlier board, my learned friend was one of the member, but in the newly constituted committee, my learned friend has been excluded. Lord. That is the
not
main
the
grievance.
concern.
That is the main grievance, Lordship. Otherwise, Lordship, we have already stated in our affidavit, Lordship.
What about the objections he has raised that constitution is not in accordance with the provisions of this Act of 2019
No, Lordship, we have.
or the directions given by the apex court?
Lordship, we have already constituted this one in our page 26, Lordship. Page number 26 of our affidavit, Lordship.
What is the running page?
Running page 26 in PL 2 of 22. I mean,
The affidavit by the Director of Social and Justice Empowerment as a.
Lordship. That paragraph 8 regarding constitution of transgender board, Lordship.
When they got.
That IA, Lordship, IA 3658 of 2023.
So it simply said the President Department states that the transgender welfare board has already been constituted, has been already constituted in Assam. This is what your statement?
No, Lordship. May I read, Lordship?
Yes.
Paragraph number 8, Lordship. That with regard to the statement made in paragraph 3 of the interlocutory.
1 minute. You're referring to the affidavit filed in the IA,
Lordship,
not in the PIL.
not in PL, IA.
Yes. That with regard to the statement, this,
Yes, Lordship.
read,
Made in paragraph 3 of the interlocutory application in the PIL, the deponent begs to state that as per Assam Gazette notification clause 7.3.3, the tenure of non-official members of Transgender Welfare Board is for 3 years, and accordingly, the term was over on 18/5/23. The matter was informed to the government by letter number so-and-so, dated so-and-so. The government incorporated new members from transgender community of Transgender Welfare Board on 1/8/23 by notification number so-and-so, and forwarded to all concerned necessary action. Then para 9, Lordship. That with regard to the statements made in paragraph 4 of the interlocutory application of the PIL, the deponent begs to state that the core committee was formed only for the purpose of providing a framework for drafting state policy for transgender. As the state policy has been drafted and finalized, the function of the core committee is no longer in existence. Then paragraph 10, Lordship. That with regard to the statement made in paragraph 5 of the interlocutory application of the PIL, the deponent begs to state that as per the state policy, there is no specific procedure laid down for selecting non-official members of the Transgender Welfare Board. However, as Department of Social Justice and Empowerment, Assam is involved with the welfare of transgender community. The department is aware with the person, NGOs, etc. involved in the welfare activities of the transgender community. The new members are actively involved in the welfare activities and they are found to be capable and efficient. Considering their capabilities, the department has nominated the new members along with associate vice chairman, Lordship.
So who is the chairman of the welfare board now?
Welfare board chairman will be the minister, Lordship.
Sorry?
Minister,
Minister.
Minister concerned.
Minister concerned, Lordship. That is the formation is already been given, Lordship. Chairperson is the
Chairperson is the minister.
Minister.
Senior most secretary will be the vice chairperson. There
That is
will
given,
be
Lordship.
one from the community, trans community, who will be termed as associate vice chairperson. Other are all members to the board.
Page 36, type copy there is always list of being given.
And what is the function of this board?
To look after the various welfares for the community and its development. But more importantly, your lordship, whomever they choose, we have nothing to say on that part. But the selection process should be transparent.
Is there any procedure provided under the rules?
No procedures.
No.
No procedures has been laid down. That is only the issue. Because even if your lordship may recollect in the Yogesh Dubey versus Association for Development and others, the Supreme Court has specifically said.
But the previous board was also followed by the same process.
No, your lordship.
Same
The previous board was as per the recommendations by the advisory committee and the core committee. But after that tenure got ended of the previous member, simultaneously at one night, they select some of the community members, they publish the notifications and we don't know.
Is it required for them to seek the opinion of the advisory committee for the purpose of constitution of the
Yes, your lordship.
nomination of the members of the board?
For that reason only the advisory committee was constituted by the then government.
That in black and white that they'll nominate the members as per the advice of the advisory committee or recommendation.
The minutes may be available with the department, your lordship.
Where is the duty, where is the state government is bound to take recommendation into consideration of the advisory board? Maybe on earlier occasion,
Your lordship may, for the time being, may just see page 23.
23 of
23 of the IA.
This board you have constituted or nominated the members in August, whether it is functioning.
Yes, Lordship, it is. It's being duly.
Please apprise us what proceedings they have taken since August.
For that, I have to take the instructions, Lordship. That,
You furnish the, what instructions, what proceedings this board has conducted
Lordship, I will.
from last, this August. The new board or new members are nominated.
Lordship. I will.
Please bring the records.
Record. Lord,
How many sittings? What are the proceedings?
Lordship.
And what about constitution of the protection group? Is a protection cell?
State level protection cell.
Yes, what has happened on that?
As regard the constitution of the protection group, my lord.
Cell.
That's protection cell. Yes.
Don't be so excited. Let me submit. Don't be so excited.
There is nothing exciting.
All right. It's nothing.
But in PIL two, my lord, our affidavit has been filed by Nitul Gogoi, my lord. There, my lord, we have my lord, placed on record, my lord.
Page number?
But I'm sorry, my lord, the running page is not available with me, my lord.
Who is the person who filed the affidavit?
Affidavit by Nitul Gogoi, my lord. It was filed in the month of March 22, my lord.
Nitul Gogoi.
Nitul Gogoi, my lord.
The one which was filed on 21st August 2023.
My lord, it was filed in the month of March 22, my lord, by Nitul
10th of
Gogoi.
March.
Yes, my lord.
Yes,
Paragraph 10, my lord.
10.
Para 10. But with
Yes.
with regard to the statement made in para 19 of the PIL, the deponent states that the Ministry of Home Affairs by letter number so and so dated 21st of January 2021 directed the Chief Secretary to the Government of Assam to form a state level cell under the Director General of Police Assam. The Assam Police Headquarters by letter number so and so dated 10/2/2021 requested the IGP CID Assam for setting up of a state level transgender protection cell to monitor the cases of offences against transgender person are to ensure timely registration, investigation and prosecution of such offences. The Special Superintendent of Police CID Assam by this letter number so and so dated 17/3/2021 informed that the CID may not be in a position to set up the cell as per Rule 11(5) of the Transgender Person Protection and Rights Rules 2020. Moreover, the offence under the said act is non-cognizable and hence cannot be registered by police. The responsibility to rescue, protection and awareness is concerned personally lies with the state government in social welfare department, police would extend all assistance and cooperation in this regard. On receipt of the letter, the CID, Assam Police Headquarters forwarded the letter to the Secretary to the Government of Assam Home and Political Department for a direction from the government by letter number so and so. The government reply at that time was awaited. Well,
It simply wrote a letter to the IG and he said they will not be able to constitute this and then
Because-
you have left it to the social welfare department. Where is the protection cell?
But the difficulties they have, the difficulties they have applied, you know, because they said that the offences are non-cognizable, that is why the police cannot. And
Whatever it may be, maybe the Director General may not be able to form the protection cell, but even if it is the responsibility of the social welfare department, then what they had done?
Eventually, subsequent to this period, the department got bifurcated and this entire subject has gone to the social justice department, for whom my friend is here.
Now, your lordship,
Shifting the responsibility, you don't have any responsibility. Social welfare. Now, who is for the social welfare department?
The social welfare, earlier I appeared, now it has gone to the social justice department. So my friend, he appears for that.
So, what is your stand on this? Inspections, whatever it may be, ultimately, if you, first of all, as we have already asked you, you produce the record of the proceedings of the welfare board. And what steps the social welfare department or justice department has taken for the purpose of setting up a protection cell?
your lordship,
But there is another affidavit club subsequently filed. But there, running page number 69, kindly come to page 69, subsequent to that,
Yes. 69.
page 69, para 3,
Para?
paragraph 3.
Yes.
But subsequent to that, the Home and Political Department in exercise of Rule 11.5 of the Transgender Person Protection of Rights Rules 2020 by notification number so and so dated 9/8/2020 constituted a state level transgender protection cell to monitor cases of offences against transgender persons and to ensure timely registration, investigation and prosecution of such offences. By another notification dated 9/8/2022, the government in the Home and Political Department in exercise of Rule 11.2 has constituted district level transgender protection cell in District of Assam. That lordship at page 71, lordship will find the state level protection cell and the district level is the next page, page 72.
You are already constituted.
Yes, yes, Lord.
It was constituted in when?
The state level on 9th of August 22. And page 72, Lord. It is also 9th of August 22. Lord.
You want to say something?
yes, your lordship. Your lordship, in their first affidavit, they stated that all the cases pertaining to the transgender communities are non-cognizable. That is why they are not in a position to constitute the cell. Now, when in the subsequent affidavit, they have constituted the cell, not a single trans members are there in the trans cell. These are all cisgender persons are there. Your lordship may just see Rule 11, Sub-Rule 5 of the Trans Act.
Main petition, PL.
Here it says every state government shall set up a transgender protection cell under the charge of a district magistrate in each district and under the Director General of Police in the state to monitor cases of offences against transgender persons to ensure timely registration, investigation and prosecution of such offence. Now the question arises, when this committee has been constituted, but there is no any office sale, we don't see. There is also no office. How come the GRP police is arresting the transgender persons, taking them in the police station and stripping off clothes?
That may be an incident which.
No, your lordship, these are the prejudices.
But the your main concern with this PIL is regarding constitution of the Transgender Welfare Board and the protection cell.
Sale.
Now, once the state government or the respondents have come with the case that we have already done it, we'll do one thing, we'll ask them whether they have been constituted, whether they are active or not. We'll ask them to file the status regarding their working, and then we'll proceed further.
Yes, your lordship.
What is this?
Because your lordship
And so
will
far
see.
as regarding the incident which you have pointed at in your IA, that yes, that is there, but in accordance with law, if they have done any officer or any other authority has done something wrong, not in accordance with law, we'll take care of that for that purpose.
Yes, your lordship. Because your lordship, on the last year, the government of Rajasthan formulated this state level transgender protection cell, where they have included trans persons into that.
But if it is not mandatory for them to include in that, yes, should be there. But if it is not mandatory, we can ask them, we only advise them to include one person from that community in the protection cell also.
Yes, because that why that is important. But because whenever the cases comes.
It is expressly provided in the act or the rules, we can't issue amendments of this effect. That's the only thing. Be careful. Then consequently, the respondent has submitted that the Transgender Welfare Board as well as the Transgender Protection Cell has already been constituted. Having considered the said statement by the learned counsel for the respondent, we deem it appropriate to direct the state to produce the copies of to produce the relevant record regarding the proceedings undertaken by the Transgender Welfare Cell as well as the Protection Cell.
Welfare Board and Protection Cell. Welfare Board and
Welfare Board and Protection Cell. List on.
Malabri, give us 3 weeks time. Let us
List on, so it's 3 weeks time. Can you produce what proceedings they have drawn or how they are working? Please inform this. Yes.
Now, your lordship, what happened is same kind of issue was reflected in the Punjab and Haryana High Court. And where one of the recent order, it says that it is essential to ensure that bodies such as Transgender Welfare Board acquire teeth and do not remain cosmetic features.
That's why only we have asked for what they have done. Yes.
Now, your lordship, in the next PIL 6.
Yes.
It's pertain to the advertisement.
Advertisement?
Advertisement in the Assam Police Department, your lordship. Here, your lordship, may just see at page 72.
Yes.
Here, what happened, your lordship? In 2021, this advertisement was came into existence, where they have separated the female part, whereas no doubt they have it is an appreciable step that they, for the first time, the Assam Police Department has came up with an advertisement by including trans person. But the derogatory steps what they have taken is they have collapsed that trans part with the male. And now, as a result, the evolving principles, what was being set as a criteria for applying, the transgender persons, not a single transgender person was able to apply. And subsequently, what happened is the government issued admit card, the advertisement was conducted, and now all the selected candidates are in the training. After that, when this was argued before the court, The other side said that from the next advertisement, we will make some criteria and evolving principles so that transgender persons can apply. But till date, nothing is there on record.
What is that statement of the state that they are going to evolve a new criteria for the transgenders?
It was been verbally submitted before the court.
Specifically,
It is available on the, it is on record on the YouTube.
But specifically in this PIL, they issue the
That
prayer.
is the benefit of the recent.
The prayer was made in this PIL for republishing of that particular advertisement by amending both the advertisement and should formulate the suitable criteria. During the proceeding of this PIL, my lord, ultimately we got the instructions that no trans person applied in that advertisement. That was there. Subsequently, my lord, we filed the affidavit in this matter, my lord. Lord, in fact, my lord, we have filed the affidavit on behalf of page 131 by Nitul Gogoi. In that, my lord, we have said that the state, the central or the state government have not issued any guidelines till date for providing separate reservation to transgender person in educational institutions and public employment. However, as per existing policy of reservation, benefits can be availed by transgender persons if they fall under existing categories of reservation like any other candidate. It was page 132.
132.
132. It starts at page 131, the para 3.
Number 3, with regard to statement, the parent, deponent likes to know. The
Affidavit by Nitul Gogoi, my lord.
Gogoi.
By Nitul Gogoi, it is page 131, my lord, as it is reflected in my clip. There was subsequent affidavit after the advisory letter issued by the National Human Rights Commission, my lord, by Sanjeev Sekhar Rai at page 147. There also, my lord, we have taken the same stand, my lord. Page 147 is affidavit filed by Sanjeev Sekhar Rai.
The affidavit of David Nathan.
David Nathan is the earlier affidavit.
Nitul Gogoi, yes. The guidelines still for providing separate reservation in educational institution and public employment, however, as per the existing policy, reservation can be availed by the target. They fall under the existing reservation like the other candidates. Okay.
And the subsequent affidavit filed by Sanjeev Sekhar Rai, my lord. There was a advisory, my lord, my learned friend.
State also. How the IGP has filed affidavit on behalf of state of Assam?
He has been authorized to do that, my lord.
Huh?
He has been authorized to do.
No, you cannot be authorized.
That is only what going on.
Any other officer of the state, how the IGP can file that?
But
Dealing with the law and order or the policing, how the IGP can file?
I find that.
And who is this Sanjeev Sekhar Roy? Again, inspector.
He is also an
assistant
APS
inspector and
official.
There is no stand of the state available. These are policy matters of the state. How can the police officials swear affidavit, Mr. Nath?
But I'll take it up, my lord. But otherwise, I find that he has been authorized to do that. That's why we filed now.
He has been authorized, but he is not competent.
In that same affidavit, if your lordship may just see para 8. It goes with that as per the information of the deponent, the central and the state government has not issued any guidelines till date for providing separate reservation to transgender persons in educational institution and public appointment, which is very conflicting to what the direction of the NALSA says. In 2014, the recently, your lordship, what happened is the division bench of the Madras High Court has also gave out an order saying that 1% reservation should be, horizontal reservation should be, is a mandate for the transgender persons. So now, even what they are stating in para 4 of that their affidavit, that is contrary to what the Supreme Court says in the NALSA judgment, because the Supreme Court specifically says.
How many states have provided this, has done the reservation, this provision for reservation?
Karnataka, Kolkata, Orissa,
They
now
have already
yes,
incorporated in the rules,
in their state policies.
state policies.
Yes.
So, necessary amendment in the rules,
No,
recruitment rules have also been made.
No, your lordship, in regard to that reservation, the Supreme Court specifically said in an NALSA judgment that transgender should be treated as socially and economically backward classes.
So they
For
could be
terms of
included in
public
the OBC
appointment,
or different classes, BC, which class
Yes.
they belongs to?
there may be some other caste. Transgenders may also have many categories, maybe
No,
ST, SC,
in the sense that
OBCs.
There is a specific provision in the rules. We can't give a direction to the police authorities or any other department to provide reservation or to do something until and unless there is amendment in the rules itself.
But again, if that may not be done, then again, that is a contrary to what the act says, your lordship. Because your lordship, in chapter 2 of the act, it says the denial or discontinuation of or unfair treatment in educational establishment and services thereof will be treated as prohibition against discrimination. That chapter 2 of the act. Then it further says the unfair treatment in or in relation to employment or occupation.
Okay, this,
But in fact, in the PIL, the state has been, they have made particular state represented by the Director General of Police. The department is not made a party here. Kindly see page 3.
page 3.
Page 3. The state of Assam represented by the Director General of Police Assam, Special Director General of Police, and the Chairman State Level Police Recruitment Board. Department is not a party here.
But ultimately, it's a. Right, but. Okay. This. Petition. In the form of public interest litigation is filed on behalf of the. All Assam Transgender Association. Seeking. Direction for the respondents. That is the police department. To re-petition amending the advertisements in question. With the further prayer that the respondents be directed to formulate the suitable criteria and options in the physical test, medical tests, etc. Stop it is further prayed that the Assam Police Department be directed to formulate various important policies in the upcoming future for empowering the transgender in the state. Stop. It is noticed that the state of Assam is implemented through Director General of Police Assam headquarters. As by Director General of Police Assam. However, we feel that for the purpose of addressing the issues raised by the petitioners in this petition, the response of the state government through the respective department is required to be is necessary. Hence, we direct the petitioners to include the concerned social justice department or welfare department?
Home department. The police comes under
Home department. This is the ultimately the social welfare
Policy has to
department
be,
will look
policy
into
has
all
to be
this.
taken up by them.
Yes.
It is social justice department.
Social justice
Social
department.
justice and social justice
But-
and empowerment.
Now, and we deem it appropriate to include the social justice department through its secretary as party respondent number 4 in this writ petition. Amended prospect will be filed by the petitioners, counsel for the petitioners during the, within a period of 2 days. Let notice be issued to the social welfare department of the government of Rajasthan. No, sorry, government of Assam through the secretary of the said department. Another, you are appealing for social justice department or what?
The same also Mr. Das was there. Yes,
Mr. R.M. Das, appealing for the social justice department is directed to accept notice on this behalf of the respondent number 4. Copy of the PIL petition, this writ petition along with the requisite documents we supplied to him within a period of 1 week. Mr. Das may file a response to to this writ petition within a period of 6 weeks thereafter. List the 6 weeks thereafter. On the next date, the name of Mr. Das be reflected in the cause list as counsel for the response.
Lordship, initially we haven't made the state party because the recruitment issues.
But now if you have raised this issue that they have to provide a
Because
policy change.
yes, that it will do, your lordship. But however, the Assam State Police Recruitment Board has been looked after by the DGP only because he is the chairman of the.
Now we have
Police Recruitment Board is implementing, my lord, only.
Yes.
And kindly, my lord, the Social Justice and Empowerment Department.
social justice and
And
empowerment.
empowerment, lordship. How like?
Okay, fine.
86.
Item 14.
But this application is for condonation of delay, my lord.
Who is appearing for the respondent? Non-applicant. You are appearing.
My lord, the respondent is appearing.
Have you filed any objection?
No, my lord. No objection.
No objection in condoning the delay? Principal for consideration of the application filed on behalf of the appellant state. Appellant state for condoning the delay of 280 days in filing the present appeal. It's from despite service of notice upon the respondent. No response to the, no counter to the application is filed. Heard learned counsel of the parties. Having heard the, full stop. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay in filing the present appeal. Hence, the IA number so and so is allowed. The delay of 283 days in filing the present appeal is condoned. Let writ appeal be listed for admission on so and so. Let writ appeal be registered and listed for admission on so.
Item 15.
In this case, in the IA, there is a delay of 280 days. But we have taken steps for service of dusty notice, but the report has not come yet. But I prefer 2 weeks time, my lord, for filing affidavit in the matter, my lord, after service of dusty.
At the request of the learned counsel, list after 2 weeks.
Item 17.
Yes.
There is a delay
38
of
days.
38 days, madam. The bank.
Well, Lord, I am for the writ petitioner respondent in item number 17. File-
17.
Yes, madam. I'll take some time to file a objection in item number
17 days delay,
38 days delay, madam.
not 38 days delay.
My lord, I've been instructed, my lord, to,
What instructed will
Because my
record
lord-
record your serious objection.
my lord, the delay has not been properly explained, what I could understand. And what they have written that in paragraph 3.1,
Yeah.
that the application was filed on 18/11 for certified copy and was delivered on 30/11. That is incorrect statement. If your lordship goes to the judgment, it shows the judgment was applied on, copy was applied on 22nd of January and it was on the same day delivered. So this is an incorrect statement made on oath for condemnation, my lord. 3.1, they have stated that they applied on 18/11 and was delivered on 30/11. And at page number, my lord, 9, if your lordship says the application was filed for certified copy on 22/1 and on the same day it was given. And if your lordship goes to the explanation, there is absolutely vague, my lord, when and when it was sent and how.
22/1 and they have preferred this appeal on
24th
24th of January.
January, my lord, in paragraph 3.1.
2 days, within 2 days they were filed.
No, yes, that is how, but this is absolutely an incorrect statement that from 18 to 38, this application for certified copy was pending. And this is an incorrect statement made by a bank officer on oath, my lord.
Well, if he wish to file, let him file
Into your
objection. file.
previous opposition, it seems your matter is somewhat weak.
Sweeper, appointment of a sweeper.
Sweepers, my lord.
Sweepers.
What is the problem?
My lord, there is a problem. Why? Because whether a writ of mandamus, a direction can be given by the court in view of a judgment of the Supreme Court. Constitutional
What
bench,
directions? What
direction given by the learned single judge. Immediately, because there was advertisement for the post of sweepers, part-time and part-time and full-time sweepers. Now that at 2014 advertisement. Now, in the meantime, 2015, there was a circular issued by the Finance Department, Government of India. There should be a ban. Now, the ban on the interviews of all the banks, PSU ban, by a circular in 2015. But the fact is that the process of interview has started 2014. But it didn't end because Indian Bank, which was merged with the Allahabad Bank, 2014 it was Allahabad Bank that it merged with the now Indian Bank. Now, in 2014, this advertisement was issued. 2015, there was a circular issue of finance. Now, the bank wanted a more clarification. That clarification was given on 6th of February, 2015. 2016, saying that no, what you do, interview cannot be held so far as substuff is concerned also. So, and the clerk. So, what we have done, the process was kept in abeyance. Now in 2018, they come up before this court of interview 2014. A specific point. Well, only
My lord, in other two items, I am not representing the respondent. So in that case, the notice will have to go to them also, my lord.
We'll do that, but here in this matter, we'll condone that.
Lordship may record my objection that
Serious objection or any other word which you suggest, we'll write that.
And another thing, my lord, they have not explained the delay also. There's a statements are vague.
If the matter comes upon for consideration of the application preferred on behalf of the appellant under section 5, the limitation act with a prayer to condone the delay of 38 days in filing the writ appeal. Stop. Mr. So-and-so put in appearance on behalf of the respondent number 1.
1, 2. My lord, in item number 17, I am representing respondent number 1 to 7.
1 to 7.
Yes.
Stop. However, no reply to the application under section 5, the limitation act is 5. Learned answer for the applicant has submitted that due to some unavoidable circumstances, the writ appeal cannot be filed within the limitation. Full stop. Learned counsel for the respondent number 1, 2. So and so has strenuously opposed the application filed on behalf of the application under section 5, the limitation act, and has submitted that the reasons
There is no
supplied by the applicant in the application under section 5 of the limitation area for condoning the delay are not sufficient to condone the delay. Having heard the learned counsel for the parties and after going through the contents of the application and taking into consideration the facts and circumstances of the case, we deem it appropriate to condone the delay of 30 days in filing the present appeal Hence, the FTK IA number so and so is allowed delay of 30 days in filing the present. 38 days in filing the present appeal is condoned. Registry is directed to register the late appeal and place it place it for admission on so and so date. And what about this?
This, I think, notice has to go. 18, 19, these are.
18 and 19, my lord, is a common
Common
judgment, my lord.
judgment has been passed.
But for that purpose, we have to issue. the
Issue a notice.
19, then I issue notice of the, issue notice of.
18 and
under
19.
Section 5, the limit is like returnable on so and so.
18 and 19. 18, 19, both.
18 and 19, yes.
Deeply opposed.
For admission, item 20.
May it please your lordship. Well, the appeal is against an order passed by the learned single judge. There was an NIT issued by the respondent Anchalik Panchayat for settlement of a market.
What settlement of?
Of a market, bi-weekly market. And that NIT, in the pursuant to that NIT, the appellants as well as the private respondent had submitted the bids. The bid of the appellant was found to be the highest and the valid bid. And accordingly, the tender was issued in its favor. Settlement was issued in its favor. This was challenged in the writ proceeding before the learned single judge. Now, while deciding the writ proceeding, my lord, the learned single judge has found to the conclusion that the bids of the appellant before your lordship as well as the private respondents were incomplete in certain respect, and therefore eventually the direction has been issued to redo the exercise. Your lordship will kindly find that observation at page 144.
On heading, they will release the appeal of-
Because
अभी आएगा वो उठेगा कब?
Who is running the market now?
Now it is the committee, the Anchalik Panchayat itself is running it. After the judgment, after the order of the Honorable Single Judge.
Okay, now the direction is to redo the exercise.
Yes.
Why are we aggrieved?
Well, redoing the exercise will mean that, my lord, a condition, particularly clause 10, which the learned single judge has said that the clause 10 should be invoked. Well, the particular clause 10 fell for consideration before this honorable court in number of other cases. And there are judgments of the coordinate benches which have held that the clause 10 is violative of the provisions of law. And therefore, the clause 10 was interfered with. And basically, in the facts of the present case, there was an interim order operating in favor of the Anchalik Panchayat, so to say that the clause 10 was kept under suspension. The order of the learned single bench, your lordship will find at page 73.
No,
And it was during
this settlement is for 1 year.
1 year.
So that is the panchayat year.
Yeah.
So it should commence from 1st of July.
Yes.
Now we are almost in February,
February.
middle of February.
Yes.
So what remains in this case now?
Because, my lord, I advanced after being selected, my lord, I advanced the KIST money and other deposits that I was required to do. Now, unless and until I get the chance of operating the market, my lord, then I'll run into loss. The settlement was made in my favor.
For how much period you are able to run them?
I was running it till the
Today, February to June.
lordship. Yes,
February to
yes,
June or-
yes, June.
February to June, what you will get?
Now, till the time the honorable single judge's judgment came, my lord, it was me who was running the market, and it will be a loss of entire revenue to me. The judgment is dated 11/1.
What interim order this court has passed in this appeal?
The status quo order, there is an order of status quo, and therefore the market is being run by the Anchalik Panchayat. So unless and until, my lord, the order of the single judge is stayed, it will be a gross loss to me. And I was the successful bidder. The clause 10 was not invoked because there was an interim order operating.
Bid was issued in your favor and when? The date, the contract or whatever this settlement was in your favor, on which date?
That is page 56, your lordship will kindly come to, it was on 30th of June 2023.
And since 30th of June 2023, you
yes.
done that up to January.
Yes. For 6 months, 7 months almost, I was running it.
You paid 18 lakhs, your price was 18 lakhs higher than the private respondent.
No, lower than the private respondent. My price was 18 lakhs lower than the private respondent, but the private respondent's bid was found unqualified because of certain deficiencies. Now, those deficiencies could be cured only by taking recourse to clause 10. But before the tender process began, there was a writ petition filed in this honorable court, and the honorable single judge passed an order saying that clause 10 should not be in operation, and the tender should be processed by keeping clause 10 in abeyance.
In
So,
this,
yes.
this very proceeding.
No, not in this very
Another-
proceeding, another writ proceeding.
Where is that order?
That page 73. It starts from page 64. Your lordship will come to the operative part at page 73. So pursuant to this order, my lord, the clause 10 was kept in abeyance and the tender process was finalized. Paragraph 18, page 73.
You are the disclaimer, I'm saying it, within that. So it is in an individual case, it's not a direction and rem.
No, the paragraph 19 says, the last sentence, only restrainment is to exercise power under clause 10 of the bid. Now, clause 10 is a provision, my lord, which permitted the bidder.
Interim order shall be understood that if the court has restrained the respondent or that is imposing the settlement of the tender, only restrainment exercise of power 10 of the bid.
Clause 10. Now, clause 10 is the provision, my lord, which allows the authority or the bidder to complete the deficiencies even after fund.
Clause 10 of what?
Clause 10 of the NIT,
Where is it?
page 46. Now, clause 10 allows the bidder, successful bidder to complete the deficiencies even after opening of it. Clause 10, your lordship will find at page 46. Last two sentences.
The tender.
Yes, the
Bazaar
tender
Ghat
for all Bazaar
Dhamma
Ghat,
Found offering
highest bid price.
Will be considered for settlement if the tender offering higher price does not enclose the relevant papers and document acted court PSNA. He shall be given
Period of
for
3 days.
submission of such papers and documents. And if he fails to submit the papers and documents, then the tender will be cancelled. That is earnest money.
Now, admittedly, he did not submit.
Your bid was of what
Got-
amount?
1 crore 52 lakhs.
And his bid was?
His was 1 crore 70 lakhs.
Was the stand of the state before the granite single judge?
Well, the state produced the record but did not file any affidavit on the matter.
Did not come with this case of since the court has restrained, one single judge is restrained. And therefore we are not invoking this 10
Clause, yes.
clause 10. It was not the stand of the state.
At the relevant period of time, there was a stay in the operation of clause 10. However,
In another matter.
Asadul Zaman versus State of Assam, that was the name of the writ petition. And the interim order was that they should, clause 10 should not be operational. However, the writ petitioner later on withdrew that writ petition, my lord. And all the interim stays were vacated, including the stay on the operation of clause 10.
No, that
So as
writ
on date-
petition, I'm sorry to interfere, my lord. That writ petition was withdrawn after disposal of the writ petition by the Honorable Single Judge here. It was after disposal of this writ petition, those writ petitions were withdrawn.
So as on date, my lord, clause 10 holds the field.
It was on the date of the judgment, my lord. That observation of the Honorable Single Judge was still holding the field.
That was not.
Because your lordship, you'll find, I have given it in the chart itself, my lord. The writ petition was disposed of on 11th of January. And on 23rd of January, this 3325/2023 has been withdrawn. So after 12 days.
Yes, who do you want to say? Who is for the private dispute?
I am for the private respondent, my lord.
Yes.
Your lordship kindly see, my lord. The clause 10, without going to the clause 10 now, my lord, your lordship kindly see his settlement order. Page, my lord. 66, page 67, my lord. His settlement order. His settlement order, page 56, my lord. There is the impugn order before the single judge, my lord. You are hereby informed that the Balishatta bi-weekly market under Nagaon Jilla Parishad is settling with you for the year 2020 to 24 with effect from 1/7/2022 to the 36/2024 at amount of rupees 1,52 lakhs for the 12 month against the annual bid of the sunset. It is mentioned here that in the compulsory observation and condition mentioned in the tender notice running in the market bill. However, this settlement shall be depending on the final order of the Honorable Guwahati High Court case number WPCC so and so, so and so, so and so. So that, my lord, even otherwise, my lord, today, my lord, that order is no more, my lord. So his, my lord, oxygen only to, my lord.
325/2000.
That has been withdrawn, my lord. That is, my lord, that has been dismissal on withdrawn, my lord.
That in that the suspension of the clause 10 was there.
Yes, no, the suspension of clause 10, yes, there is stay order on clause 10, my lord. And my lord, in fact, my lord, clause 10, my lord, that was specifically challenged before this honorable court. And this honorable court, my lord, felt that it is a good law, so it will be prevailed. Against that, there is a writ appeal. That is also dismissed, my lord. But now they are taking the advantage of another judgment, my lord, where only observation was made, not a specific challenge was made, my lord. So my submission before you this stage, my lord, your lordship kindly see even his settlement without it, there is no case at all, my lord. Then, my lord, that settlement order goes after the passing of that judgment, my lord. It will that not been challenged. There has already been withdrawn, my lord.
This validity of clause 10 has already been upheld.
Upheld, my lord, in a reported judgment, my lord. And very interestingly, my lord, after filing of this, my lord, it appeal, my lord. The same writ petitioner, my lord, challenged the clause 10 of the, my lord, before this single match, it is also dismissed, my lord. Very few days back, my lord.
After this decision.
My lord, after this. He particularly challenged this because knowing that, my lord, that clause is, what is that clause 10? Clause 10, my lord, if something defect in the highest tender, then he will get chance to rectify his tender, my lord, in 10 days, within 3 days, my lord. So here in this case, my lord, that was not given to me. That's why I'm challenged before this honorable court, my lord.
Was that order whereby the clause 10 validity is upheld?
My lord, that is, my lord, reported judgment. That order was reported in, my lord, 2020-23, 1 GLT 368.
Party.
Party name? Suru Jamal. Please, sir.
You are referring to?
My lord. Your lordship, kindly see, my lord, para 5, my lord. 5/8. It is in the para 5, my lord.
As indicated above.
As indicated above, there are 5 writ petition in which common question has been arise, challenging the validity of the impugned clauses. Then, my lord, your lordship, kindly come to page para 8, my lord.
Yes.
The para 8, my learned counsel for the petitioner have immediately drawn the attention to the offending clause in NIT, which clause 10 of which cases, of those cases, clause 11 in one cases, my lord. So that clause 10 has been challenged specifically. So, my lord, finding is that, my lord, your lordship kindly that way goes to a para 23, my lord. Para 23, my lord.
Yes.
Para 23, my lord. Having said that this issue is required to be educated so far as the petitioner who has been submitted their bids in response to the approach at NIT concerned is challenging residing this clauses given 5 reasons for NIT, a minutes of the exhibition data so and so bid without there being a condemned. However, in the case of other document which has also been necessary this time, and this court find once this in the concern the learned council department of the 5 activities that employment this court is further notice that the period of waiting is 3 days time has been to the father in document which is not given to the case, not been available or could not be censored. That this clause further stipulated the liberty not an ultimate one, but only 3 days or where the of the second has been within the thus the clause of the considered opinion, this court cannot be termed to be constituted as unreasonable, arbitrary, and rather it can appear to be conscious with the principle of fairness and transparency. So influence. So last part of the paragraph 23, my lord.
There was an appeal filed against 23/11/2022.
This, upholding the.
Yes,
validity
that is the order.
Appeal file.
Appeal
Appeal was
file.
filed and dismissed.
Dismissal.
When?
That is like to do. Dismiss on 9/6/2023, my lord.
Yeah. Coordinate bench.
Learned single judge, after taking note of those judgments,
It doesn't agree.
Yes, Mr.
All of these particular judgments which my learned friend has referred, that has been taken care of by the Honorable Single Judge in page 67.
That we have been the.
Interim order was,
State.
yes. And the Honorable Single Judge has proceeded on the basis that prior to that judgment, my lord, there was a judgment of a coordinate bench available, which upheld that clause 10 is not valid, is not a valid condition.
That was
And-
not taken into consideration.
Yes, and following the observation of the Honorable Single Judge came following the Constitution Bench decision of the Honorable Supreme Court in Pranay case, that if there is a previous judgment by the coordinate bench, then regardless of the differences, that has to be followed. So in that premise, my lord, the Honorable Single Judge had passed an order of stay in respect of clause 10.
Fine.
Now, when the clause 10 was,
That's right, that's right.
yes, when,
Now, come to your settlement order.
yes, settlement order only says that it will be subject to the outcome of the writ petition, 3755. Now, writ petition,
The writ petition came to be dismissed as withdrawn or whatever it may be.
that is,
Order goes.
no, that is after the judgment of the Honorable, after the impugned order, not before the order impugned. This withdrawal, 3755, the settlement order, page 56 says that my settlement will be subject to outcome of withdrawal of disposal of 3325/2023. Now, 33/2025 of 23 got disposed of on withdrawal after the judgment of, after the impugned order, not prior to the impugned order.
Here this matters. After the quest consideration, there is a conflicting judgment of the division benches.
My lord, in my respectful submission, the division bench did not go into the aspect of validity of clause 10. The particular judgment which my learned friend has referred, in the order passed by the division bench, it is very much clear that the consideration on respect of clause 10 was not gone into. Paragraph 12 of the order of the.
Ultimately, the writ appeal dismissed, the affirmed learned single judge order was.
No, did, your lordship, I'll just read out one paragraph. So far relating to the issue that there are two divergent views of the two learned single judge in respect of validity of the offending clause 10. This court is not inclined to entertain such an issue at the behest of the present appellant. So the honorable division bench's order cannot be understood to be a final seal of approval on the validity of
Mr.
the.
Datta, what my lord, the Honorable Chief Justice is saying is that since there are two divergent views, the issue is still at large.
Yes.
The appellate court cannot take a side without taking a view on which of the two issues are correct.
Exactly.
So this matter will require consideration.
Yes.
So the only option is we admit it and fix the date of hearing.
Yes, that is, but I would, since I have also made an application for stay of the judgment, because unless and until, my lord, the order of the single judge is not stayed, I'll be loser. He is not going to lose anything. He his own sworn statement in the writ petition was that his bid was incomplete.
That is difficult because if we ultimately uphold the order of the learned single judge, then you are nowhere in the picture. It is he who will get the. So you can't say that he is not going to be the loser.
My lord, in that circumstance, my lord, my submission would be in that circumstance, the direction should be on the committee to go for a fresh tender. It will not revive an invalid tender cannot be revived, my lord.
Having heard the learned counsel for the party, we are of the opinion that matter requires consideration, admit no need to issue notice to the respondents as parties are already represented. Place this matter for hearing on 12th of March.
Well, 12th, I have some difficulty. Can it be on some other day?
Other date then
28th.
you have some difficulty then. 14th. Yes. 14th.
14th. In that, the status quo order may be continued, my lord.
Interim order if I need to continue. till next date.
Obliged. Next item 21 is also same. It is out of the same order, but two writ petitions were decided.
Fine, same, सभी में same order रहेगा, common order आ जाएगा. Yes.
Item 22, along with item 50.
May the lordship, Malada, yeah, about the cooperative society for participation of the election, because we have been prohibited by a notification. Yesterday, Malada, the department has filed an affidavit. They have interpreted that previous 5 years from the last date of election in 2016 and up to 21. But they have not denied about the executive officers letter that the mandatory is not required for us to appear, that they have not denied. And now there is a IA by those 14 eligible candidates. Malad, one objection is there regarding that IA is this. They are not a party to the writ proceeding. If they have come before the division bench to be a party, they have to file a leave petition. Without a leave petition, they cannot be a party in the writ appellate.
This is the order wherein we have passed the interim order.
Interim order. We have received the affidavit yesterday only, my lord. Some allegations are there that we have not attended the AGM from 2016 onwards.
With this, that the AGM was regularly took place
My lord, there
for 5 years.
from 16.
During the COVID period.
My lord, during the COVID period, only in 2020, AGM was not held. Otherwise, 4 AGMs were held. And the requirement under the statute is at least minimum 2 AGMs, my lord, they are required to be present. So their
Out of
case,
5.
out of 5.
My lord, they have taken the period from 2016, 16 to 21.
Obviously.
And now in 19, there was no AGM because in a writ petition, the board of directors came and they were dissolved. So to the maximum, the language was previous 5 years. Now they are taking the previous 5 years from 2016, when the last election was held.
But if the no such meeting during the COVID period was the COVID period held, then certainly previous 5 years relates to the year 5 years होगा strict such में
Preceding 5 years.
Preceding 5 years,
My
meaning
only-
preceding 5 years when this meeting took place.
My lord, 16. My lord, there are allegations that we have not appeared from 2016. Yesterday, we have received the copy. If your lordship gives us 2 days to file a rejoinder to that, my lord, whether we have appeared or not in those elections. We have received that yesterday only.
And it concept of the appellant place for place some time to file counter to the response filed on behalf of the respondent 4. Respondent number 4. Respondent number 4. List on so and so.
There is the IA for it.
My lord, item number 50, my lord. I am for the applicants. Lordship, I may be allowed for impleement as a party respondent, my lord.
We'll hear on that day,
We'll hear on that.
We'll hear on that day.
Obliged, lordship.
So the
Your stand as well as the respondent number 4 stand is the same.
Lordship.
We'll hear that
My lord, the interim order to continue.
interim order to continue till next week.
Okay.
I need video list along with item 20. List along
Sir,
with item 20
First must need to go, next is.
or the next date, dear sir.
IA one size.
Item 50.
Item 50. So but then list along with that.
7 to
50 may order, but then I list along with
20.
WA number 41/2024 on so and so date.
15.
Item 24,
Lordship, in this case, I am appearing for respondent number 1, Lordship. As per our instruction, Lordship, representation is not received by the authority. After communicating regarding the writ appeal, Lordship, authority has come to know about the fact, Lordship. So they will do some time is needed, Lordship. Received the representation earlier.
Because instruction yet to be received. Later we pass over.
Concept of the government, the London Council, government advocate MD Bora. RB Bora seeks some time to complete the sections list on so and so. 3 weeks के बाद किए थे।
May it please your lordship. The state level recruitment commission issued 2 advertisement, my lord, for filling up a post of class 3 and class 12 post. The lordship will find the advertisement at page 18.
Yes.
My lord. Lordship will kindly take note of the educational qualification. The minimum qualification is HSLC. The advertisement deals with the person who has minimum qualification HSLC and class 12 maximum. Now, my lord,
HSLC, class 10 or equivalent examination passed.
My lord.
The equivalent examination IT pass certificate, so on. Yes.
yes, and the maximum qualification is class 12.
Okay.
My lord. May I just take your lordship to page 19, my lord? The application submission procedure.
Candidates are required to apply in prescribed through so and so.
My lord, through an online application form, Roman 4, your lordship will find, candidates must fill up all the fields in the online application which has marked as mandatory. And the 5, it says candidates should be cautious while submitting the application form. Once the online application is submitted, there will be no scope for editing, correction, and resubmission. Now, what has happened, my lord? The Southern community, who happens to be the MOBC, falls in the MOBC category. When the application form, they click the MOBC, they are required to select the caste. Now, the Southern community was not enlisted in the application form. And therefore, my lord, they could not apply in the recruitment process, my lord. That's the grievance, my lord.
Which community?
Southern community, my lord. It's a community which falls within the category of MOBC, my lord. That is the grievance, my lord.
You may, maybe a cause which you are raising is a genuine concern.
My lord.
But how this public interest litigation
My lord.
can be available in that matter, sir?
My lord, this, my lord, the
Ultimately, it's an individual right of the candidate who is desirous to apply for that.
in fact, my lord, the organization who represents the Southern community,
Whatever it
the
may be, sir.
people's, my lord, the unemployed youth of those community, my lord, they have brought it to the notice of these authorities that because of this reason we could not.
If they are they can be brought into your notice, then they can also approach this court, sir.
My lord,
They can approach to this court also
my lord,
by way of filing a separate petition claiming their individual rights. Sir, in the matter of recruitment and all, where some condition is not conducive to that a community, particular community, then certainly the individual has his own right.
yes, of course, my lord.
Then
But the
in a strict sense, sir, how can we?
Well,
entertain
if your
PIL in
lordship will
these
kindly
matters,
take
then
page
every matter will come to the court as a public interest litigation. How can it be?
for the unemployed youth, my lord, of this community, it's in a large number, my lord, they could not submit this application, my lord.
Maybe lakhs of numbers,
My lord.
but ultimately in every recruitment, if a particular community is having some or a different set of persons, who are deprived by any condition of that, and they may file a PIL.
My lord. If your lordship will kindly have a look at page 31, my lord, page 26 is the representation that was submitted before the authorities, and it was forwarded by page 31, my lord.
Fine.
So even if my lord, before the last date, if a clarification would have been given by the government that the community, my lord, because if your lordship will find the application form, we are not even required to submit any documents.
Mr. Kaushik, this advertisement was issued in October 2020.
My lord.
You have approached the court in 2024. By that time, the last date of submission of application.
Yes, last date was over, my lord. Last date was over,
remains in this
but
petition?
no,
What
my lord.
direction we can give?
Page 19, the selection procedure, my lord, the written test and interview. As on date, my lord, it has nothing has been notified.
Whatever it may be, sir, last date, your qualification is required to be taken into consideration on the last date of filing of the application form. If you have not filled in the application form, you have to approach earlier in this.
Well, we
era.
could not fill in the application form because of the
Sir,
application
the
procedure
cause
which
of
has been
action- The cause of action was available
was,
to the concerned persons on the day when the advertisement was issued.
my lord.
And now you approach this court after this applications are already, last date for application has already been came to an end, and now you are approaching this
The-
court in 2024.
My lord,
How can we upset all this?
my lord, the application, the last date was 29 December. Before the last date, my lord, the authorities, we submitted a representation before the authorities, which was brought to the notice of the authorities by page 31 by the deputy
If
commissioner.
the authorities have not done anything before the last date, you should have approached the court at that time.
My lord, true, my
Now-
lord, but
now-
your lordship will kindly appreciate one thing, my lord, the
First of all,
advertisement
the
deals with, my lord.
maintainability of the PIL, we are very much doubtful about this.
My lord.
That question has been in the last occasion, my lord. Today, my lord, my lord, honorable court, my lord, directed to satisfy on the, my lord, maintainability issue. Because it is a purely service matter and individual rights are concerned.
Individual rights
Like,
are
in my respectful submission, it would not be a service matter because, my lord, these people, my lord, they have been deprived from getting an equal opportunity in a public employment, my lord.
Is some set of people in this belonging to this community, not the whole community.
But the unemployed youth of this community, my lord,
We say
and your
unemployed
lordship will
youth,
kindly appreciate one thing, my
there
lord,
is
this,
unemployed youth in every category and every section of the society. That doesn't mean that they approach this court by way of PIL and we are going to entertain it. Strict sense, we are not going to entertain. Either you satisfy us or otherwise you may have a liberty to approach the appropriate forum for for your individual rights of the members of the particular communities.
if I can take your lordship to the prayer in my PL, my lord.
Yes,
My lord, may I just take your lordship to the prayer in the PL, my lord? One prayer, my lord.
yes. Set aside the cost, the recruitment.
My lord, prayer D, my lord, page 15.
Nature of amendment was issued unless the government under the category within the application form and all advertisement was said, that is also absolutely.
Hello.
not that. This is not a matter of public interest.
Because your lordship will kindly appreciate, my lord, this recruitment process deals with a person, my lord,
Tomorrow,
who is.
every community may approach for one or another grievance. Can't entertain the PIL in such matters, sir.
Oh,
Strict sense, sir, the Supreme Court has, if you want, we'll pass a detailed order.
No, my lord.
Supreme Court
I-
has
I
clearly laid down some norms under which the PIL can be entertained.
Well.
And certainly, whatever your prayer is there, it is not covered by those norms, sir. Not
You know,
at all.
this recruitment process, my lord, deals with a person, my lord, who has a minimum qualification of matriculation
Whatever it may be, sir.
and maximum higher secondary.
Pass.
And these, my lord, these people, my lord, your lordship will kindly appreciate, these people, this belongs to an
For
MOBC
that
candidate.
reason,
my lord.
if a illiterate person, even a illiterate person having some individual right, he has to approach the court individually, not in a manner of PIL.
True, my lord, the individual right will accrue, my lord, when their applications would have been rejected or the
There are so many difficulties in it. Last date is already over. First
But-
of all, the maintainability of the PIL, and second, the last date is already over. What directions now we can issue the direction that all the proceedings and all the advertisement should be quashed and set aside.
No, my lord, even if the government issues a corrigendum clarifying that the Chowdhury community is entitled to participate in the employment.
Can't.
That,
That is for the government.
well,
They may
that,
issue or they may not.
that the grievance of the people, my lord, would be survived.
No, suppose you approach the government and whatever it may be, and if they are
We
not
already
acceding
approached
to
the-
your request, you have an individual cause of action, you may challenge it
My lord.
individually, not in this PI.
There is already a representation pending before the authorities, my lord.
Sir, on your behalf, at least we can't give a direction to the.
No, this is a
authority
represent,
concerned to consider that representation and pass an order.
my lord, the representation is filed by a body, my lord, which represents the community, my lord.
Not-
And that was forwarded to the authorities
The
by,
petitioner, you have filed any representation in your individual capacity or as being a representative of that community?
as a representative of that community, my lord.
You are the signatory of that
No,
representation?
I am not the signatory.
Then that is also a hurdle. And yes,
My lord. Then I'll place for withdrawal, my lord, with a liberty to approach the appropriate place.
okay. This writ petition is filed by the petitioners in the form of public interest petition. Essentially with a prayer that the respondents be directed to include the
Southern government.
with essentially with a prayer to prayer that the advertisement dated 27/10/2023 and 30th of October 2023 issued by the respondents for the purpose of recruitment of
Grade 3 and grade 4 posts, my lord.
grade 3 and grade 4 posts. It is also prayed that the respondent number 2, 3, and 4 be directed to enlist the Chodang community under the category of OBC, MOBC. And certain ancillary prayers have also been sought for, with stop. After attempting to argue the matter for quite some time, learned counsel for the petitioner on instructions has submitted that he wants to withdraw this writ petition, however seeks liberty for the members of the Chodang community to avail appropriate remedy available to him, available to them under the law for redressal of their individual grievances. Dismissed with liberty as prayed for.
Oblige, sir.
Item 26.
Please, my lord. My lord, the PIL is on the issue of seeking adjournments and formulating guidelines regarding the same. So,
Seeking adjournments and formulary guidelines.
guideline, because, yeah, so in judiciary, we have a judicial precedent of justice delayed is justice denied. This precedent is further elaborated in Article 21, which states that right to speedy trial is part of Article 21. Many a times, this honorable court, Supreme Court, and multiple law commissions have come out that the pendency is caused due to seeking of adjournments and unethical adjournments by the councils. Now, adjournments as a whole is not wrong. It finds its source in Order 17 under CPC. My lord, if I may take you to page 20. In page 20, CPC under Order 17 states, court may grant time and adjourn hearing. The court may, if sufficient cause is shown, sufficient cause is the word of concern, at any stage of the suit, grant time to the parties to any of them, and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing, provided that no such adjournment shall be granted more than 3 times to a party. Now, how can these adjournments be granted? For this, my lord, I will take you to Rule 2A. When the hearing of the suit has commenced, it shall be continued from day to day until all the witnesses in attendance have been examined. Then it comes to B. No adjournment shall be granted at the request of a party except where the circumstances are beyond the control of the party. The word of emphasis is circumstances beyond the control of the party. Number C, the fact that the pleader of a party is engaged in another court shall not be ground for adjournment. Number D, where the illness of a pleader or his inability to conduct the case or for any reason other than his being engaged in another court is being put forward as a ground for adjournment, the court shall not grant the adjournment unless it is satisfied that the party applying for adjournment could not have engaged another pleader in time. So it clearly stipulates that if an adjournment is being sought by a council, he has to make.
You are reading from, just now you read from CPC.
Page 20, my lord.
CPC.
CPC.
CPC was framed which year? In which year?
1907. 1908, my lord.
So we have come up a long way now.
Yes,
Those conditions are very different.
no, but my lord, what I'm saying is, yeah, in order to broadcast like how the process of adjournment is being abused, I have highlighted 3 cases.
Have you read the case management rules of the Guwahati High Court? You have a copy?
Yes, case management rules. I have in the Guwahati High Court rules, my lord.
No.
Case management rules.
Have you heard about it?
No, my lord.
That's the problem.
What do you want by this PA?
I want by this bill that as the Supreme Court by have shown in Annexure 9, they have established a committee to look into the process of seeking adjournment and to frame rules and guidelines for the same. My lord, similar kind of committee may be formed so that the rules
The
for,
Supreme Court has already formed a committee. It is not confined to the Supreme Court.
but it's only for Supreme Court because it's
Where
in,
is that committee, constitution of that committee?
it's on page 79, my lord.
Already areas committee here. We have several number of committees dealing with these issues. And you want to place to formulate a formula for every court, a universal formula to regarding adjournments and all these.
No, what I want is that the guidelines stipulated under Order 17 and Section 35B of Part 1 of the CPC should be adhered to, my lord.
What's your name?
Ritam Singh, my lord.
Ritam Singh, you have filed this petition in your personal capacity.
Yes, my lord.
Have you ever never sought any adjournment in the court?
No,
At
my
any
lord.
point of time?
No, my
Never?
lord.
Never.
No, my lord. My lord, I had even accident and that time, last year I was for 3 months in the hospital. I engaged another counsel to appear for my behalf.
Yeah.
Because my lord, if I may demonstrate to my lord how the process is being abused. Because for that, I have also shown like how this honorable court, Guwahati High Court, had given out a through Registrar General circular stating that cases under NI should be completed within 6 months in consonance with the Supreme Court guidelines. Even after that, in my case, which was filed after the said circular, till date, my lord, we are in the copy stage. And even if the circular,
You are practicing in the trial courts also?
yes, my lord.
You've gone through the condition there?
Yes, my lord.
In those availability of infrastructure and the conditions of the courts and the case load, do you expect that every case will be taken up on day-to-day basis and it can be decided within 6
No,
months?
my lord, my prayer is not on that. My prayer is limited that adjournment should be given in adherence to CPC.
Always the courts are giving adjournments in accordance.
But it is not been demonstrated in the order sheet, my lord. The order sheets are also not uploaded in the lower court. As there was a guideline from the Supreme Court dated 2010 that order sheet within 48 hours should be uploaded online. I have demonstrated in civil case, in the money suit, the learned district judge, civil judge, she uploads it, but in the check bounce case, the NI case, the judge doesn't upload the order of each date, my lord. My lord, I have even highlighted the Supreme Court cases where Supreme Court in MS quoted.
Will the media carry this tomorrow morning?
No,
Or
my
we'll
lord.
keep it pending for 1 more week.
My lord, there is nothing to do about the media. It's about the poor litigants because litigants are at the core of this issue because
Okay, then please answer some questions.
Yes, my lord.
What is wrong with the case management rules of 2007? Please point out what is wrong. What is wrong about the track one procedure to expedite disposal of cases? Please point it out. What is wrong about it?
My lord, I have not gone through the same.
Then that means you have not done your research before filing this writ petition. And you have done it only to get the media attention.
No, my lord, because the
Then why have you
NIA,
filed it? You should have done your research.
my lord, I have shown the same to the register judicial as well. I took his advice on the
Just a
same.
minute. What is wrong with the decisions taken by the Area Management Committee of the High Court? Where correction is required, point out.
My lord, the correction is required that when an
What is
adjournment is
wrong
given.
with the decisions taken so far? You are not aware.
No,
So you just saw order 17 and
no, my lord, because there was adjournment we given in my case also, where for taking step, adjournment was provided when under section 35B clearly states that if you are taking a step.
Mr. Singh, we don't want to discourage you. But before taking this kind of a project in hand, you must be more vigilant and do some research work. Did it not occur to you that this kind of a petition could have been filed by people 20 years back, 15 years back?
My
Don't
lord,
do adjournment.
my lord, I've been facing troubles because of the same. My client, they're asking me.
Come
as
with
a-
your grievance. This is
No,
not a
my-
PIL.
My lord, multiple individual senior advocates have thereafter come and told me.
Come with your petition.
Yes.
We'll see. We'll see on the facts of the case, what is your grievance, we'll address it. Because somewhere the shoe is pinching you, you can't take the cause of the whole society like, omnibus petition.
My lord,
These
it's
are
not
not
an omnibus,
practicable. This
it's-
is what you are asking is not practical.
My lord,
Yes, in
guidelines
some
are being
cases-
stipulated. The Supreme Court is taking the same endeavor right now.
Go there then.
No, I'm asking the High Court to take it as well. And
Why
similar
you have filed
circumstances,
the-
because the.
Why you have withdrawn this earlier petition?
My lord, there was, last time Justice Jamir, he was agreeing to it, but the government council, they had issues regarding two of the statements that I had made. So they asked me to remove those two statements and file a new
What
fresh petition.
statement you have made?
My lord, it was regarding that I had made a general statement about the councils. He told, he had asked me that.
Statement were made against all the
Councils,
Against all the
councils.
state councils or in general?
General. Working time.
Justice Jamir told me to take those statements out and file a fresh petition.
So have you gone these Guwahati court management rules?
No, my lord.
Why?
My lord, it was not in my knowledge. my lord.
Not in your knowledge, then what research? My lords have already pointed out.
My lord,
what
I have
research you have
done the research through the National Judicial Data Grid. The data I have found from there with regards to the pendency of cases in
That
the.
data is up to date.
Yes, my lord.
Subject to my lord, the Honorable Chief Justice approving it, we'll post it next week. Give us a proposal, which according to you've implemented, all cases will be disposed of immediately. Come up with that proposal.
As per
What is your
the,
suggestion?
within day-to-day basis, give us a, give your.
Give us your proposal. But you have to take responsibility of that.
Okay.
Give a proposal. What is the direction we will issue?
My lord, for that, it would be better if a unanimous committee must be formed between the judges and the senior advocates.
You are the committee.
You first give your suggestions, will then, if your suggestions are up to mark, why to form a committee? We'll implement those suggestions. That all the pending cases, yes, with certainty be decided within this time period if this procedure is to be followed. You suggest the procedure.
My lord, my PL is not about the time period, my main concern is that
You have just now pointed out that the Supreme Court or in that case.
regarding adjournments.
This NIA cases should be decided within 6 months. How we can decide these within 6 months? How
There is a
the
pilot
courts
project
can
being
decide it?
initiated by the Supreme Court. I have highlighted the pilot project as well.
You come up with a proposal, how to stop adjournments, you give it. If it is good, we'll accept it.
Okay, my lord.
After attempting to argue the matter for quite some time, the petitioner present in person raised some time to go through the High Court, the Guwahati High Court Case Management Rules 2007, and also raised some time to submit a proposed
Concrete proposal.
submit concrete proposals which may facilitate the disposal of the cases in the district courts of the state of Assam as well as Guwahati High Court. By avoiding frequent adjournments. List on when.
How much time you want?
My lord, within a week, if you, my lord.
Within a week, you will be able
Yes, my
to.
lord. Yes, my lord.
Okay. List on so and so date के बाद की week के बाद की date.
Oblige, my lord.
Item 28.
My lord, in this case, my lord, though petitioner has been working on contractual basis, my lord, but there was an advertisement regarding, my lord, filling up 7,500 posts, my lord. And my lord, my age is about to, my lord, over, my lord, there. So my lord, upper age limit, my lord, I crossed, my lord. An application was submitted before the authority, my lord, prior to, my lord, submission of my forms, my lord. But that has been rejected, my lord. That is my simple case. So that, my lord, my case is that, my lord, petitioner is already a government servant, my lord, on contractual basis. Such type of relaxation may be given, my lord. My lord, as a on service.
To the government servants.
Only, my lord, the relaxation clause, my lord, 45 years, my lord. What is there already, my lord, India of the year 1951, my lord. Page 72, my lord, relevant question.
The last date is over already.
No date is mentioned, my lord. No date has been mentioned in the advertisement.
No date.
No date mentioned, my lord.
Last date, submission of last date is not there.
But when he first approached, then there was no date.
Yes.
Thereafter, during the pendency of litigation, the last date was also advertised. The last date has gone by in February 2023, a year ago. He has been in litigation, and just wanted to point out at page 54, the OM on which he claims that he should be considered for relaxation lays down two conditions, madam. Either it is in the interest of fair dealing or it is in the public interest. Only then a further age relaxation can be afforded. At page 54, the last line, Lordship, in the interest of fair dealing or in public interest. Now, his is a case where he says that I have all the qualifications. I work as a contractual teacher under the Sarva Shiksha Abhiyan, and I want to apply under the government of Assam. So the statement that he is a government contractual employee is also not correct. He's an employee under the Sarva Shiksha Abhiyan, not under the government.
Under the
He's under the Sarva Shiksha Abhiyan, my lord, which is a central
Sarv
scheme.
Shiksha Abhiyan.
My lord, it is not under the government of Assam as such.
Others is eligible, my lord. 2 times it is already offered, my lord. That research that
As of
eligibility
now,
test.
what is your age?
My age is more than 45 years, my lord.
45 years.
Yes, my lord.
And the date of superannuation is,
60, my lord.
the age of superannuation is 60.
60, my lord.
So up to what stage the government would allow the people to enter into the service?
My prayer is only, my lord, as I am already in the government, central government scheme work, my lord.
Scheme, it's
Yes,
not
ma'am.
a government
Yes, my lord.
job.
But,
You are engaged under a scheme.
but all the eligibility criteria in that post also, my lord, it was, my lord, by open process, my lord, I applied, my lord, in due process. Appointment letter was also given, my lord. And I have already cleared 2 times state, my lord, TET, teachers eligibility test, my lord. Also B.Ed also, my lord. All, my lord, thus my prayer is only to consider my candidature, not to, my lord, obtain any job, my lord. From this,
Leadership considered, what do you mean by after consideration, if you are selected, you'll forego the government job?
no, my lord, my, only my, just to
By
cross the
consideration,
hurdle, my lord.
I'm simply asking for my consideration, not for any appointment.
No,
Okay, that
at
we
the time of,
that we can,
no,
that
no,
we
no.
can do, okay, consider his application, even if he is selected, the petitioner opted that I am not interested in government job. Simply only a direction for consideration that we will do.
Only to, my lord, cross the hurdle of age, my lord, upper age. Only that much, my lord,
You are
because,
only seeking a consideration. You just now I said, KK, I am only seeking that my application be considered, that we will direct them.
because others she is quite eligible, my lord, for the such type of post, my lord. Already posts are lying vacant also, my lord.
You are from general category,
OBC, my lord.
OBC category. OBC is already up to 40 days in respect of OBC 2 years, that is up to 42 years. 42 years already relaxation is already there. And now you have crossed 43 years.
Yes.
Then why not we extend it up to 55 years? Suppose tomorrow a person come, ke sir 55 years okay, please allow me the relaxation. Why not?
No, here, my lord, as per
Why
law,
not? What's wrong in that? If we allow a person of 45 years to avail the opportunity for appointment, then why not 55 years or 57, 58, 59, or even for 1 month less? Why not?
but already
You
there
should
is
have I was the government servant a month back.
no,
Now,
my lord.
what is the criteria of giving this?
No, no, only there was one, my lord, government earlier one notification in the of the year
Better
19.
to leave it to the state government regarding this relaxation and all. The court says no jurisdiction to do. Okay. This intra-court appeal is filed by the appellant, being agreed with the order dated 8/11/2023 passed by the single judge, whereby the writ petition filed by the petitioner seeking a direction for the state government to grant relaxation of age, relaxation of upper age for the purpose of appointment on the post of
Assistant teacher, my lord.
assistant teacher has been rejected. The learned single judge, taking into consideration the fact that the appellant is already 45 years of age and
At the time of advertisement, 43 years.
any direction to the respondents to relax the upper age of the petitioner would amount to direct the respondent authorities to violate the clauses of the office memorandum dated 2/9/2020. And therefore, no case for interference is made out. But stop having heard the learned concept of the appellant, and after going through the material available on record, we don't find any case for interference. Hence, this intra-court appeal is dismissed.
Okay.
Item 30.
May I please your lordship? So we have filed a reply, but it is not on record as yet.
When you have filed the
We
reply
filed it yesterday, lordship.
yesterday,
Yesterday. And
reply to the writ petition is filed on behalf of all the respondents.
no, lordship, on, it is affidavit, rejoinder affidavit, lordship.
You have filed the.
I have filed a rejoinder affidavit. They have filed one
When
affidavit
the
and
concept of the appellant has submitted that he has filed affidavit in rejoinder yesterday. Stop, office to take the same along with the report, list on so and so. 4 weeks per time.
lie, lordship.
Item 31.
May I Lordship, we say income tax appeal. Lordship, earlier we took steps, not as per Lozima Court, we have directed to take fresh steps. Lordship, I have taken steps today, Lordship.
Okay, then concept of the appellant has submitted that as per the orders passed with the Lozima Court, first steps have already been taken, of which registered to check and proceed in a, registered to check and proceed.
Item 32.
Lordship, in this case, service was accepted by the dishonorable court, but nobody is appeared. The case is thorough fixed for admission hearing, Lordship.
It is
Lordship,
listed for admission only.
Lordship,
It is listed for admission.
yes, Lordship. Lordship,
Admit.
Lordship, till date it is not admitted. Have framed some substitution of consideration of Lordship. Lordship, in this case, what happened, the assessing officer issue notice under 147 with a particular amount that 10 lakhs has been escaped notice of the authority. But while doing the assessment, he discovered that some other materials was there. Thereafter, that was challenged before the appellate authority, that was rejected. Then appeal was also rejected. Lordship, under section 147, explanation 3. Lordship, substantial question number 3, Lordship, 2 and 3. I mean, two are the same. They're all brown. Eight number, 10 number, 7.
Which substantial question you are referring to?
Lordship,
Out of these three substantial question,
Lordship, 2 and 3.
second is nothing, it's a simply a ground.
Lordship,
And what about 1 and 3?
Lordship, under section 147, explanation 3, during Lordship assessment proceeding, if the assessing officer found some other materials, then he is empowered to add these materials. Lordship.
So you mean to say that cannot actually
Yes, Lordship.
if no addition is made on the issue, which was mentioned for reopening the case, ignoring the explanation 3 and so and so.
Yes, Lordship. And this question came before two high courts that has been decided in favor of the revenue Lordship. So the explanation 3 was inserted in 1989 Lordship.
This question came for two High Court, Punjab and High Court and Karnataka High Court. And in paragraph 5, 6, Lordship, this question was considered.
Having heard the learned concept, it is noticed that notice issued to the respondent has duly been served. However, none has appeared on behalf of the full respondent. Having heard the learned concept of the appellant, we found that the following substantial question of law is involved in this appeal. लिख देना इसको. Whether the findings recorded by the Honorable Tribunal is contrary to the provisions of explanation 3 of section 147 of the Income Tax Act, that if no addition is made on the issue which was mentioned for reopening of the case, comma, the assessment officer cannot reassess the income in respect of cannot reassess the income of the SSC in the case of escaped assessment. Full stop. The concept of the appellant is at liberty to raise any other further substantial question of law at the time of hearing of the appeal with the leave of this court. Full stop. Admit, issue notice to the respondent, returnable also and
Much appreciated.
Admit fresh notice be issued to the respondent number, sole respondent, returnable on term. Yes.
Item 23.
In this case,
I have filed an additional affidavit yesterday, incorporating
I
the
have
entire.
received it just today morning, so I pray for some time to produce the same.
Okay, learned concept of the petitioner has submitted that she is in receipt of the additional affidavit filed on behalf of the respondent. Today itself, she takes some time to complete the instructions. This after 3 weeks,
My lord,
4 weeks.
obliged, my lord. My lord, 4 weeks would be a little too much because this matter pertains to
3
formaldehyde, my lord.
How would make a difference in 4 weeks and 3 weeks?
My lord, I was
Okay, 3
expecting a
weeks,
short.
3 weeks.
Obliged.
Item 24.
May I please the lordship? Lordship, in this case, I am praying for 2 weeks time to file affidavit in Nagaland.
My lord, at present, my lord, at present, the petitioner does not know the exact status of the FIR submitted by him to the officer in charge of the vigilance and anti-corruption police station. My lord.
This PIL is for what?
My lord, the petitioner is praying for a high-level inquiry against the erring officials of this Guwahati Municipal Corporation who had given illegal appointments to 500 numbers of persons as regular Mazdoor, my lord, creating a new post.
When this appointment was given?
My lord, appointment was given on 10 February 2021, my lord. The order is at page number 36, my lord.
Consumer, the respondent pays some time to file counter to the petition, time paid for is granted, list on so and so. It's list up to 4 weeks.
Highly obliged.
Item 28,
May I please, Rossip, in this case, the respondent is supposed to file affidavit, my lord.
Lordship, in this matter, the affidavit has been sent for swearing. The affidavit on behalf of the Director of Land Records, Your Lordship, and also the instructions are awaited from the Revenue Department. Lordship, may kindly grant me 4 weeks' time, Your Lordship.
PTC.
ETC.
Okay. Immediate.
Yes.
My lord, there is a, my lord, on the motion that there is a prayer, my lord, interim prayer will be considered later on.
What
my lord.
interim period you are asking?
My lord, that impugn or advertisement, my lord, this will be under silence before lordship, my lord. My lord, they have already prepared a select list, my lord. So any appointment or sending for training subject to the outcome of this matter petition, that may be observed, my lord.
What interim period you are asking for?
That is my lordship may come to page 94.
94.
94, annexure 4. This advertisement is under silence, my lord.
Yes.
These, well, according to they have prepared a list, my lord. I come to know, my lord. Already they have prepared a list, my lord. They are supposed to send for training. So, my lord,
So now, what is your grievance?
my grievance is this, my lord, this advertisement issued on the basis of 2023 rule, my lord. That is not applicable in BTC, my lord. It's issued by the Board and Territorial Council without the.
So what interim relief you are seeking? Interim relief, what you are, the interim relief you are seeking?
My lord, actually, my lord.
Page
already-
19.
Read.
Already they have prepared the list, my lord. When I filed this case petition, my lord, that list was not prepared.
Read your interim relief.
My lord, I'm reading, my lord. My lord, page 19, my lord, pending disposal petition, be pleased to stand. Resting the respondent BTC authorization for making any selection or recommendation process for the post of land record assistant in pursuance to the impugn advertisement dated 31st/5/2003, annexure 4 during the pendency of the repetition or pass such other necessary order, my lord.
You have already made the recommendations. Yes. You already made the recommendation.
That recommendation has not yet.
Why?
Process is not.
Then file your reply, otherwise we'll say all this.
Lordship, this is the rule was amended by the state government, Lordship. We are just following that rule, Lordship. So here the amendment
File
is
your
under
reply,
silence.
whatever the response.
Lordship.
On behalf of the state as well as the
Lordship.
recruiting authority, who is the recruiting authority?
We are Lordship, BTC, Lordship.
ETC.
Why you are not filing the?
ETC. Lordship, I am representing respondent number 3 and 4, Your Lordship. The affidavit on behalf of respondent number 4 is ready and it has gone for swearing. And I am awaiting the instructions from the Revenue Department, respondent number 3.
In respect of my rule under silence, my lord, is responsible by the state, my lord. In case of my advertisement, it is by the BTC, my lord, which is not
If
person
the
to
rule
the rule.
itself is under challenge, then you have to file your response.
Yes.
File your response, otherwise you'll stay all these proceedings. Equal and in council for the respondent number 1. 2, 3 and 4 are the same. 2, 3, 4, 5, you are the.
My lord, 1, 2 is my lord
Yes.
BTC, 3, 4, 5 by the state, my lord.
3, 4, 5, I am representing.
Mr. So-and-so put in appearance on behalf of the respondent number 1 and 2.
Yes.
MS so-and-so is put in appearance on behalf of the respondent 3, 4 and 5. The opportunity to file counter to the writ petition is granted to the counsel for the respondents. List on so-and-so. Reply, counter to the writ petition be filed by the next date of hearing. Bolo tarikh bolo, yes.
3 weeks, Lordship.
My lord, till then, my lord, no action is
Fix the
taken.
date.
My lord,
Yes.
my lord, till then, no action will be taken on the basis of the, my lord, input advertisement, my lord.
On 11th, Lordship.
11th of
March, Lord.
March. Yes.
My lord, till the next date, my lord, no action has been taken on the basis of the input advertisement, my lord.
We may, no adjournment.
My lord,
He's asking for an interim order.
Interim order, whatever the selections is, will take place, that will be, that would be subject to this petition.
that may be, my lord, observed, my lord.
That is on innocuous order. This is
My
always
lord,
there.
otherwise, till then, they may proceed with my
It is
lord.
always there. It is innocuous order. Even though if we mention it or not mention it, it is always there. Writ petition is pending and any recruitment or any further proceedings are subject to decision of this. Yes.
That what at least, my lord, in the order may be put, my lord. Otherwise, my lord, they will not, there is a no order, my lord, they will proceed, my lord.
There is no order. Please. Yes.
Obliged.
Okay. Yes.